For pronouncement of judgment, Criminal Appeal 12 of 22, matter pertaining to Isle bench.
Criminal appeal fails.
And consent for the appellant is submitted that this matter has become infectious, dismissed as infectious. Yes.
Item number 14 to 27.
My lord, with the consent of the respondent, I beg to mention item number 24. 24.
Yeah.
My lord, my senior is indisposed, so matter may be taken up on next Thursday.
You are for? You are for appellant?
Yeah, Food Corporation of Hindustan Council, FCI.
When?
Next Thursday, matter may be taken up, my lord.
Thursday or Friday, any day.
Next week? Yes.
Next.
Yes.
Yes, my lord, matter may not be taken up on 30 and 10th because our seniors, SM Chaudhary sir will be at Supreme Court. So 30th and 10th.
Whatever the date. Yes.
May it please your lordship. May it please your lordship. Lord, with the consent of the other side, I beg to mention item number 20 of today's daily list. So I am appearing on behalf of Senior Counsel Mr. P.K. Tiwari, my lord. No, we have been engaged yesterday in this matter and we are yet to receive a copy of the writ appeal. So it may be taken up after Puja vacations.
Okay. Adjourn.
Obliged, my lord.
May I please your lordship? My lord, with the consent of the opposite party, I would like to mention item number 38. Kindly accommodate us for today as my senior is out of station. And your lordship may be pleased to fix the matter after vacation.
Adjourn.
Obliged. May I please your lordship? Kindly adjourn the matter, lordship, item number 25, lordship.
Wrong in the order. You are for the,
I'm for the appeal, lordship.
what's wrong in this order of the learned single judge?
Lordship, my
Similar
senior is
relief was granted to the similarly situated person. What's wrong with that? Yes,
My lord, item 39 supplementary.
you sought the consent of the other side.
yes, lordship.
Adjourn. Yes, item number?
39 supplementary, my lord. Actually, this case was listed on my request, my lord. But the appellants have told that they have engaged Mr. K.K. Monto, senior counsel, to argue the case. On the other hand, matter is extremely urgent, eviction matter. It may kindly be listed tomorrow, my lord.
You are not, no more a consent.
No,
Then what remains?
This is the desire of the.
What's wrong in the order of the learned single judge? We don't find any iniquity in the same. What is your
No,
right?
we will satisfy your lordship on that line. Kindly take it out tomorrow.
Don't find any. Okay, tomorrow.
Tomorrow, highly obliged.
May I please your lordship? Lordship, with the consent from the other side, I beg to mention item number 30 as my senior Mr. S.K. is out of station.
Item number 30.
30. Finally, matter may be taken up after puja vacation.
So for consent of the other side.
Yes.
Adjourn.
May I please, Your Lordship? I beg to mention item number 35. Perhaps my Lord Justice. Now,
35, my lord, I have some urgency, my lord. I have been advised from my friend, by my friend from Aizawl, my lord. It's a matter of 2020 and the person has retired in 2017. Not a single paisa has been given to him till now, my lord.
In the item number 35.
35, my lord.
35 is the.
I understand, my lord, some other arrangement may be made, my lord.
Arrangement, we can't say. Let us see.
My lord,
Another
that what is
Make a
it?
request, we'll
My
consider.
lord.
On the
Obviously.
administrative side, you make a request, we'll consider.
Right.
Yes,
Obviously.
May I please, Your Lordship, I beg to mention item number 36 with the consent of the other side, Lordship. May it come up after vacation, Lordship.
adjourn.
Deeply.
Obviously.
may it please, Your Lordship. Lordship, I'm praying for listing of a reputation, my Lord. Matter pertains to Surface Act, my Lord.
Surface Act, now what's the urgency?
My Lord, bank was, my Lord, supposed to take over my possession
Go
on
to the Deputy
21/9.
Tribunal. Go to Deputy Tribunal.
My Lord, as per my knowledge, my Lord, PO is on leave, my Lord.
Whatever it may be, we can't entertain this.
My Lord,
In
I may
surface
be heard.
matters, there is no question of entertainment of any writ petition.
My Lord, due to non-availability of PO, I was.
This can't be. Next week, laga.
Next week.
Or in Friday. Friday.
27.
Discuss on Friday. Yes,
May it please, Your Lord. Lord, I may be allowed to move an urgent read appeal tomorrow, my lord. The urgency is that and
who is we can't restrict you to, you move
already filed, my lord, may be taken up tomorrow, my lord.
tomorrow, what's the urgency?
My lord, the urgency is that, my lord, an illegal AGM stroke election was held in a cooperative society, my lord. The appellant as well as 20 other shareholders, my lord, raised complaint. Pursuant to that complaint, the registrar of cooperative society, my lord, disapproved the AGM. The two reasons were cited. First is that, my lord, many shareholders signed twice in the attendance sheet. Number two reason assigned was that, my lord, there were signatures against dead voters. That order of the Register of Cooperative Societies was interfered with by the learned single judge, saying that, my lord, non-application of mine, my lord.
They have to.
And pursuant to that,
25th.
25th. Highly.
Daily list for orders, item 2.
May it please your lordship. Order please, left.
Yes. Yes,
Yes, madam. I have filed my affidavit, madam.
see, I've gone through that affidavit.
Yes, madam.
How can you justify?
Well,
Until and unless that order is reversed, you have no option except to comply with it.
well, they have accepted the appointment because that screening process, which was initiated in the year two thousand
Whatever
twelve.
the facts may be, we can't take up the matter on merits now.
Well,
This is
in-
not the clear, while In the contempt jurisdiction, we can't consider all these things.
But thing is that, my lord, they have accepted the appointment with the condition that they will.
Whatever it
forgo-
may be, you should have then get the order reversed.
In fact, I have filed
Review
a-
application was
Then
dismissed, my
get
lord.
the order reversed.
We have filed a review, my lord, that was dismissed on the ground of delay, my lord.
Whatever it may take.
On that deliberations, my lord, during the review application, that deliberations was there, my lord. In fact,
Maybe.
my lord was,
Whether this order was, the order passed by the division bench was interfered with or not.
it's not interfered with, but
Not fair
during
interfered
the-
with them, there is no option except to comply with that order.
my lord, during the review petition, when deliberation was going on, that aspect was brought on your notice to
Sir,
this honorable
You
court, my lord.
just show us, that we can go through, go into the merits of the case while deciding a contempt petition. You show any law? Consider it.
Yes, my lord, I'll try my best, my
No,
lord.
nothing. You can't even, you'll not get any such.
But after all, my lord, they have forgo their right, my lord.
Whatever it may be, sir, you should have mentioned it before the division bench. If the division bench has committed any illegality, get the order reversed. What else we can do?
In fact,
Once the order is there and if it is added.
in fact, my lord, during the deliberations of the review petition, that fact was brought on record.
Legal, you have to comply with this.
During the deliberations of the review petition, that fact was brought on record, my lord.
Okay,
But
then
that
what
was
happened
not
in the
cons-
review petition?
that was not
Dismissed.
considered on the ground of,
Not considered, not
on the ground of
considered,
delay
you
only,
should
well.
have Challenged it, but
on the ground of delay, my lord.
whatever it may be, sir, you should have challenged it. Until and unless this order is there, we are not satisfied.
So, my lord, may give me some time so that I can,
Nothing doing. You call the officer who is responsible for that on the next date. If you are not complying with, the person should remain present before this court. For sentencing, that's all.
my lord, give me some time so that, my lord.
No time at all, sir. This contempt petition is pending.
Yes,
since
that I understand.
2018.
That I understand, and it is,
6 years have passed.
it is a bona fide belief of the contender
Your
that
bona fide belief
since
or
they have
whatever it may
accepted
be,
the fresh
we are not
appointment, my lord.
satisfied with that.
They have participated in the screening process on their own, they have participated.
So you should have mentioned this fact before the division bench.
Yes, I did, my lord,
When
but it was not considered.
not
on the
considered,
ground of
then
delay, my
challenge
lord.
that order until and unless that order is.
That is why
reversed,
I'm-
We are
that-
not supposed to.
That is
take
why
any
that is why, my lord, I am praying for some time so that I can think over it, my lord.
No,
That's,
nothing.
that's
doing.
the,
Don't
that's the
think
only
about it.
reason,
Nothing. doing.
that's the only
Okay,
reason
this contempt
I'm praying for
petition
some
is
time, my
fine.
lord.
Okay, take your own time. We'll pass an order as per the procedure. You take your own time. Consider, what do you mean by consider?
My lord may fix it on
Nothing.
next week so that I can, once I can deliberate with the officers that this is the
Whatever.
scenario, my lord.
Look here. This contempt petition is filed by the petitioner complaining that the directions issued by this court by the order dated, by judgment dated 10/7/2018 in writ appeal number 304 of 2014 has not been complied with despite repeated requests by the petitioners. Full stop, para. This court, by the order dated 10/7, by judgment dated 10/7/2014, has set aside the termination order dated 2/11/2010 issued by the DEE Assam in respect of the petitioner and has also set aside the order dated 7/8/2014 passed in writ petition number 6071/2010 and direct the state respondents to forthwith take back the petitioners into their service as assistant teacher in their respective schools by passing necessary orders. It is further observed by the division bench that no order for payment of back wages is made as there are no pleadings by the contempt petitioners of this effect. The division bench has further observed that the period without duty shall be considered as break in service, and the said period shall count for the purpose of service benefits, including retirement benefits. Full stop. Against the judgment dated 10/7/2018, the state has preferred and review petition, which also came to be dismissed.
My lord, it was dismissed on 21/2/2024 by your lordship's order in IA Civil,
21/2/2024.
in IA Civil 819 of 2020.
An additional affidavit is filed on behalf of the respondent. with
One
the
minute.
Respondent number one, justifying the action of the respondents of not complying with the directions given by the division bench by the judgment dated 10/7/2018. As a matter of fact, in the additional affidavit filed on behalf of the respondent number one, the matter was the matter, matter is, there is an attempt to contest the contempt petition while touching the merits of the case. Full stop. We are of the view that in the contempt jurisdiction, while exercising contempt jurisdiction, this court cannot go into the merits of the case. And prima facie, we are satisfied that the respondents are guilty of willful disobedience of this, of the order, of the orders and directions passed by this court. Hence, the notice is issued to the respondents to show cause why they should not be punished for committing contempt of this court. Full stop. Finish for. The contempt of this court. Response on behalf of the respondents be filed within by the next date of hearing, if they desire so. This matter on when.
Well,
It will come with the compliance report or. face
yes,
the
yes, my lord, yes, my lord.
consequences.
That I will ensure,
Or
my lord.
face the consequences, we are not.
That I will ensure, my lord. May I plead that matter will be taken up in the quick start from 4th of November, my lord.
Not 4th of
My
November.
lord, only difficulty on my part, my lord, I will not be available.
8th of October. That's all.
My lord, only
They
difficulty.
may engage some other counsel, we are not supposed to. It is not dependent upon the counsel.
My lord, only difficulty on my part, my lord.
28th of October, they may engage another counsel, we are not concerned with. Shall not be considered as breaking service. Shall not be considered as breaking. Yes.
Obliged, lordship.
We are blessed.
Item 3,
Respondent number
My lord, the dusty has been taken, my lord. We have filed the affidavit also, my lord, to that.
await return of respondent number 2 for 3 more weeks.
No.
item 4,
In this case, I may
Not
be allowed
taken
to,
fresh steps.
yes, my lord, I may be allowed to take fresh steps upon,
You are appearing for
I am the respondent number 1, my lord.
respondent number 1. Look here. Despite time granted, the counsel for the appellant on 21/6/2024. Fresh steps for service of notice upon the respondent number 3 has not been taken. The net counsel for the appellant pays for and granted a week's time. Yes, madam. To take steps for service of notice upon the respondent number 3 by registered post and AD on furnishing this such steps, let notice be issued to the respondent number 3, returnable 4 weeks thereafter.
Item 5.
May it please your lordships. My lord, in this case, my lord, pursuant to the notice which was published in newspaper and all, even government has also said, my lord, if anybody has got any suggestion, it is most welcome. My lord, today with me, Mr. Akash Borua. He is the retired principal chief conservator of forest of Tamil Nadu. My lord, only this year he has retired. Now he has done in my view, my lord, subject to also lordship may say, a wonderful job, my lord. He has in fact identified the bottlenecks. My lord, what we have done, my lord, subject to what lordship may say, we would like to give a PowerPoint presentation for about 15 minutes, my lord, where he will indicate, my lord, how the problem can be at least addressed, my lord, and it can be solved.
There are some suggestions on the part.
Yes.
Yes.
Good morning, my lord. My lord, water seeks its own level and it always flow from higher level to a lower level. The only criteria is that there should be uninterrupted free flow. If there's no interruption, the water will flow naturally. That's the basic principle of any drainage system. The primary reason for flooding of any place is that the discharge rate deficit, when the rate of inflow exceeds the rate of outflow. There may be many reasons for the difference, clogging, impediments, blockages, but that's why flooding happens. My lord, Guwahati is the only city in India, to my best of my knowledge, which has 2 rivers running through its limits, 2 huge wetlands, Diporbil, Silsako, a mighty river on one side, nearly 16 hills surrounding the Guwahati city. Guwahati was richly endowed, but poor land management has rendered Guwahati into a climate and environmentally vulnerable and unresilient city now. I'd like to briefly bring to the light of the honorable court the Guwahati drainage basin. There are 3 natural drainage basins within the limits. One is the Silsako basin on eastern part. I'll come to the map, Your Honor. The Bahini Bharolu, the most important basin, and then the Bhasista River basin. I'll be now presenting the Google Earth imagery of the basins to get a better perspective. Sorry for the, yes. Your Honor, we can see 3 colored. One is Silsako boundary, that's in green, which is the Silsako basin on eastern part of Guwahati city. The one outlined in yellow is the Bahini Bharolu river basin. And the one outlined in blue on the southern and western part is the Bhasista River basin. So basically, there are 3 distinct river basins, which are natural basin in the.
This blue part is called as?
This blue part is basically the discharge area of Bhasista River. Your Honor, you will see a greenish river flowing within that blue boundary.
Yes.
Yes, and the red color is the river, Bharolu Bahini River within the yellow boundary, which is the discharge area. And then we have the Silsako boundary. I'll just slow. Yes. Yeah. So this is Silsako is the main wetland, and the discharge area is that in green, outlined in green. So this is just to give a perspective of the existing natural basin of Guwahati city. of the three basins, the Bahini Bharolu basin is the worst affected because most of the people stay in the discharge area of these two rivers, and it is actually most important river in Guwahati city. It's no longer a river, unfortunately, it's become now a nala. All these rivers have become nala, and many people from Guwahati don't even know that these were actually a wide, big rivers. Now what you're seeing is a small nala running around the backyard. There's a tragedy of the Guwahati city. Your Honor, we have to manage the three basins if we want to manage the flooding of the Guwahati city. That's the key point. Again, the same picture. I'll come to the next one. I'm just presenting the unfortunate story how the Bahini River was the original course of Bahini River, the most important river, has now become a garbage dump. The original river doesn't exist as on in Guwahati today. It's just nala in different form. I'll come back. The Bahini origins in Meghalaya and crosses Assam border near Umtringa. There were two rivers, Bahini and Vasistha, were two other major rivers which actually historically they have separated. But they were linked by a canal which was dug in 1982. Your Honor, this is the 1972 map of the Survey of India. This was situation when Guwahati was made a capital and how the land use was existing at that point of time. And we can see this is the Bhojistha River or Barapani is flowing. This is a river, and on its right is the Bahini Bharoli River. They were two separate rivers. Now, Honor, if you observe, there is a small canal. I am showing it on this thing. This was actually a canal which was draining into Bhojistha River. In 1982, this canal was extended to join Bahini River, so that the water from Bahini flows to Bhojistha. But for reasons best known to the authorities at that point of time, there was sluice gate was actually installed right at that point. So the Bahini River stopped flowing from that point from 1982 onwards. The water actually now merges to Bhojistha River, and Bahini River actually doesn't exist. It's only the Bhojistha River flowing in different form. I'll just show.
This water from this Bahini River
Yes.
is not going into that another river through this nala.
Yes, it's going to Bhojistha River.
Yeah.
So now Bahini has lost individuality. Bahini is merged with Bhojistha River now.
Right.
That's what happened.
So this is the problem.
This is a part of problem. The most serious problem is that because the latest sluice gate here and block the natural flow, so the entire course of Bahini, from here it goes north, Hatigaon, then this is Bahini flowing, Dispur. So the entire course is now lost. We don't have the river now. In fact,
Now the place is already occupied by the persons or what?
yeah, they're encroached, they're heavily encroached. I have pictures, and not only encroached, the part of river has disappeared, totally disappeared.
On account of this construction and all.
Construction, yes, post 1972.
Now it's not possible to revive that original river, Bahini River.
Yes.
Were flowing prior to 1972.
Yes.
On account of all this construction and all.
My honor, your honor, the river is there in a smaller width, but since it's blocked on different points, if the blockages are open and the sides are widened, the river can reach.
Is it possible, sir?
It's possible. It's possible.
If the people have constructed or some, they got some title over those lands.
No, honor, actually the river in its truncated form still exists. Though it's encroached on both sides. At that point of time, 1972, the river was almost around 80 to 100 feet wide.
Right.
Now it is there. I got pictures. It's about 10, 20 feet. That still can be revived, provided we open the blockages. Part can still flow. It's still possible. I'll just come to the part. No. I'll go back to the same Google Earth images. This is the spot where the blue and the red diverges. That's where the sluice gate has been laid in 1982. I've got pictures of the sluice gate. I'll show in the next slide. So Bahini now flows left. It joins Bohista in flowing. Now this point from here, there is a sluice gate here. There is a sluice here. So there is no water, natural water inflow. So the river exists in a truncated form. It is encroached. It's narrow, but still it can revive. From this point till the Beltola market, the river is nothing but it's a closed-ended canal on both the sides. Canal is there, they are up to 30 feet wide as well. But once we let the water flow from Bahini through the natural listing, the river will revive in a lesser form, but still will revive. It's possible. Your Honor, this is a new course. I mean, like, this side is the south, it's flowing towards north. This was the original course, as you see the tree below the tree. And this was the new course where canal has been laid. And this is the old original course. As you can see, it's just nothing but a garbage dump because the house has been constructed right on top. The sluice gate was first installed. Then that area, that entry was blocked and a watchman shed was constructed. So a small shed exists on the block. And because it's blocked, because there's no water, it just, I mean, like neighboring waters coming into the this closed river. And you can see it's just nothing but a garbage sewage dump now. Yes. You see the old sluice gate. This is a sluice. The water is flowing this side. Now you see the house is constructed right on top of this water course. It's in block. It's a temporary construction. And what you see ahead is that because once a mighty river, now it's becoming a small, narrow garbage dump. It is still there. It can still be revived. Not in originality, but at least to a large extent. This is what it shows. And you can see there's temporary construction right on top. It's possible to remove this and revive the river.
How many constructions are there?
This is the only one right on top. On the side, there are some temporary constructions which are all encroachments. I'm pretty sure the authorities, if they are desires, it can be removed. That's the house right on top. So this should be the starting point to revive the Bahini River. The house must be removed.
And this gate also has to be removed.
Pardon? Huh?
This gate has also.
Yes, yes, the sluice gate has to be removed.
But what was the purpose of this placing this gate here?
Your Honor, I was inquiring with local people there. In fact, right where the sluice gate is situated, there is an idol making small firm there. So asking them that, they told me that, sir, back in 1982, we used to swim in this river. We used to fish in this river. And suddenly, so one fine morning, people came and blocked the river. Then I've also been talking to some people who are trying to save the Bharanu. So what they say that in the way back in 1980s, early 80s, there was flooding, heavy flooding in Guwahati. 2-3 floodings were happening. And since most of the early Guwahati settlements were along the Bahini River, so these localities were affected by floods. And apparently, maybe I'm assuming, presumably, they decided that if you block the Bahini River, water not flow to this heavily populated side, it will go to Bohista River, because Bohista at that point of time was flowing through areas with nothing but vacant paddy lands. So they thought we'll settle the issue that way.
Is there any order or decision on the part of the government or the authorities concerned? Because it's a big decision.
Yes.
And it was a big decision to take at the time to block this river.
Yes.
And divert the water of the river to another river.
Yes.
So there must be some consultation or something black and white. There must be some order because it's a huge gate without there being any sanction by the government authorities or something can't be set up at that time. There must be something.
I was trying to get some idea as to 40 years back issue, what would have been if there's something in written, but I couldn't gather anything. Other than the fact that because the same people are saying that last few years, people have been coming, officers had come and visited, they're visiting, then they told that they have a lot of encroachments. So maybe there are other considerations why they decide not to pursue. That's what I feel.
Because at that time, if they have set up this gate,
Yes.
Must be some deliberation on their part. And after thinking over it, if a use gate is constructed and placed it,
Yes.
what was the reason for that?
What I'm told is that they just wanted to prevent the flow of Bahini water into Dharolu River because most people are staying in that river. And that even today, the settlements along the Dharolu Bahini are the densest because the oldest. So that's what maybe the might have been a driving force to take a sudden decision. But how we develop this thing, nobody seems to have much clear idea. But the fact remains that we can still revive the course of the river. We need to revive. Now, what's happening, my lord? As you can see in the picture on the right, encroachment.
Yeah.
This is the point which is about 500 meters from the point where sluice gate has been this thing. You can see another sluice gate. It's in the iron. Recently, the NHA had laid a new flyover in Boxster. So while constructing that flyover, they constructed a new sluice gate. So we have got one sluice at near the Boxster market, another sluice near the highway. So it's a dead end. Also, we can see a clear encroachment right on the arrow mark. This even at this place, the river or whatever nala you say, it is at least 40 feet wide. But because encroachment in that, it is about number 50, 20 feet. So we can make a 40 feet wide is also a very good width for at least a dead and dying river. Now, this is the southern side of the highway. On the northern side, you can see there's also dead end because there's no freshwater inflow coming from Meghalaya, Assam, whatever. So this what we see the water is nothing but local water, rainwater stagnating there, not able to flow out. So it just slowly became a garbage dump. This is the Bahini River. Because again, dead end, there's no water inflow. It just, if you see there's no bank
Converted
management
into a
also.
Small nala and something.
It is just nala. It's all nala. It's all stagnant water. Only when Guwahati floods, some water goes into these nalas, then they go out towards Brahmaputra. That's the only source of water. And right hand side is the Beltola market. Again, we see that's where the Bahini is coming to. The point I'm trying to make here, Honor, is that because the sluice gate was constructed, two sluice gates constructed, there is no fresh inflow. The river has become a stagnant and a garbage, long pool. That's all.
So this is one of the problem.
This is one of the problem. This is one of the problem.
Yeah.
Now, Your Honor, I was telling that Bahini once it enters Guwahati, it breaks into two streams near Beltola market. One stream goes right towards Rukmini Gaon, which up to downtown area. Other stream, which is flowing from Beltola market to the present dispute complex. This is 1972. Your Honor, I will like the first present 1944 map of the Guwahati city, Private Survey of India. That's to show that there a river did exist. On the left is the Bohista River. On the right is the Bahini River flowing north. It goes north. It meets at the point near Beltola market. Once it bifurcates into two streams, one stream is flowing towards the right, which exists on that today as well. The left was actually main stream, which is flowing from that point along the present last gate to Beltola Road, and it was flowing to a wetland where the present dispute complex was constructed. And from there, both the streams met where the present downtown hospital is there, and from there is to flow like single river. Now this stretch of river from Beltola market, which is flowing to last gate to Dispur, no longer exists. This cannot be revived.
This can't.
No, not revived. I'm just trying to present to the honorable court that how we have actually killed a river. It was the biggest river in Guwahati city. The situation 1944, same situation also 1972. Same situation, Your Honor. This is the river coming up here, one going left along here. You can see already here is a small wetland. That's where this complex was constructed. And this is a right stream. The right stream still exists today. Left stream is gone. And a point here I'd like to make, Your Honor, is that because this pool was built on a wetland, there's a water body. So a considerable amount of earth was required to fill the area. That was the beginning of hill cutting in the history of Guwahati. And most of the earth, as I could gather, is that came from Hatigor, and which is near on left side of the Zoo Narangi Road. So that's the first hill started coming. Earth was brought from there to fill the earth. Even after doing that, till about 10 years back, a lot of flooding used to take place in the Dispo complex. All the ministers' quarters were underwater, used to come underwater. More earth was brought, and now the entire is filled up. We have cut the hills to create lands on the plains, and in the process, we have now gotten we are now burdened another problem of runoff from the hills. And of course, to complicate that, of course, all the hills have been now encroached. People have set up. There is no planned habitation in the hills. There's another issue in the city. I'm just quoting a line from one very famous song by one very famous group. Once there was a river, now there's a stone by Dire Straits. Your Honor, what you see in front is the garbage dump, but this was the starting point of the main Bahini stream in their Beltara market. It's defecating point now. People defecate there, people urinate there, people dump there.
This can be.
Yeah, this cannot be revived. It's difficult because it disappears. It just exists by about 100 feet. I mean, little ahead is this.
Nothing, it's a, only a, we mean to say that it's a gadda like.
Hey, the guy is a gadda like. Or aage jaake it becomes narrow 4 feet and it's lost. It's lost.
So now it can't be revived.
It can be revived.
The only revival point is that remove those two gates.
Exactly.
From there, it can be revived.
Yes, exactly.
But this is the one of the solution. But
Yes.
I think so this is not sufficient for this tackle the flooding situation in whole Guwahati.
Yes. Yes.
These are the problems. Yes, that's why
Yes.
only we are facing nowadays in those mistakes committed in the year 1972 and 82.
Yes.
Now we are facing the consequences.
Yes.
But what is the solution now?
This part, Your Honor, this story is not known to most people.
Yeah, naturally.
That's the thing.
That
So I'm just trying to
generation has-
highlight, I mean, how poor our land management was in the past and by this thing.
So
So
that is the problem in every city, in fact, big city of India.
Yes, yes, yes.
We used to go to our school in Jodhpur, and at that time, we
Yes.
find that there was a lake
Yes,
called as Nadi there.
yes,
There was a lake and we witnessed that people used to, even the small children used to bath in that lake in the time of monsoon.
Yes.
It was fully filled and it was just adjacent to the main road. And now that altogether disappeared, all colonies are raised there. And it's thickly populated area. Now it's impossible to remove.
absolutely.
That
Absolutely.
I witnessed that. So there are in almost all cities, this
Yes.
problem is there in India.
Yes.
Because
Yes.
at that time, there was no development about this planned for development or something.
Yes,
The colonies are being raised like anything, one after another. There is no access to the water or everything.
right.
That is there.
We'll move ahead.
Now, what is the solution? What solution you are suggesting?
Your Honor, the one solution is that remove the sluices and revive the, yes.
One part of that.
what is one part. Now the next problem, coming to next problem, the drainage issue.
Yeah.
Yeah, we'll come to that. Similar issue in the Silsako is a wetland, but now mostly under weeds. These are the inlets exit to the Silsako Lake. Again, same issue. They're wide streams, now they're narrow. So the inlet is compromised. The outlet is also compromised. So there's no smooth flow. That's a story in other streams as well. So the same, this Bondazan is the outlet channel of Silsako water body. Is under stream. There's no water place for inflow. The same story. The attempts at encroachment on this canal also. I'll just come to the main reason now. Water flooding goes back to more than 2 decades. It's a cumulative consequence of poor drainage, encroachment mismanagement of Bhaula Bahini, and an irresponsible garbage disposal system. I am saying irresponsible, not inefficient, because to a large extent, even citizens of Guwahati are also responsible.
We are also
Yes.
responsible. No problem.
A very major factor why flooding happening is that drains are mostly being laid across or without proper gradient. The narrow clock drains, drains should be wider. We don't have storm drains in Guwahati city. There's an impeded connectivity with the existing natural drain. This is a very important point. Drains, there are a lot of drains network across the drainage. There's no connectivity with the existing natural drainage, so water is not able to flow out. I will give examples from my own locality where I stay. Very importantly, as on date, to the best of my knowledge, the authorities don't have a comprehensive drainage map of the entire Guwahati city. So we need to have a map. Without the map, we cannot plan a holistic this thing. Same impeded water exchange because inlet outlets are compromised for the water bodies at Deepor Bay and Silsako. Unregular hill cutting, red soil coming with the runoff to the drains, clogging the drains, dumping of garbage on the drains, unregulated roadside shops and kiosks. Major reason. No practice of rain harvesting in the city. A very important point, Your Honor. Guwahati drainage and sewage works attended by different agencies, each work in silos. So there is no coordination. Left hand doesn't know what right hand doing. So we need to have one single agency only to attend to the drainage issues of Guwahati. Landslide is very common. Recently, there was a huge controversy. How Meghalaya water.
Yes.
Yes. Your Honor, whatever Meghalaya flows to Guwahati through 2 inlets. One is the Bahini River, which is the major inlet source. Bahini plus Bhagisa combined. Second is the Khanapara Canal. Bulk of flooding, as I said, takes place of Bahini River, which tends to flood area Hatigaon, Survey, Rukminigaon, Anilang, Nobino, etc. Now, the USTM issue. So what's happening, the water from USTM area, because in the highway, there's a divider. Right where the USTM road hits the highway, there is a divider, there's a cutting divider because the CRPF center is there on one side, there's a road. So all the water enters through the divider and comes towards the Khanapara Canal and enters Guwahati. Secondly, both the Khanapara Canal along the Assam border and the drain along the Meghalaya border, they're very narrow. So there's not enough opportunity for water to flow through the drains. It has to take the road route. Unfortunately, landing up in Assam side more. The water entering through Khanapara Canal is mostly flooding areas, Panjabari and neighboring. Now, in the Panjabari area, that water should have naturally flown to Silsako through the canals. As I presented earlier, 2 canals are already constructed, so there's not enough space for the huge volume of water to go into Silsako bill. Secondly, even the water from Silsako bill is not able to flow to Guwahati. It has to flow to a 10-kilometer long Bondajan canal. That canal also not maintained. So because of all these reasons, we are getting the flooding in the southern part of Guwahati. Water is not able to go out naturally. This is the, I'm saying, Khanapara Canal near a Garo, 9th mile Garo Basti, a source of origin. Now, this is the important slide, Your Honor. On the right, you'll see a culvert. This is the culvert through which the water from Meghalaya is flowing into Assam. This is just next, very close to Ganesh Mandir on the NH. On the left is the Khanapara Canal flowing along Assam border. On the right is the water from Meghalaya entering Assam to this, and this where both the water meets and flows into Assam territory, Guwahati area. This is USTM. Because a lot of controversy, there are a lot of hill cutting. Actually, this happened. It's roughly 1 square kilometer area. They have actually rampantly cut the hills. This situation not only in USTM, there are other parts of Meghalaya as well. But then this is the where our city in USTM just close to our Assam border. Your Honor, I come from Posistapur area. I retired this March. And so last 4 years, we have been having floods in my area. It was not flooding for before 4 years. Since I was here, this time I thought that when the first flooding came in month of May, and I tried reaching out to GMC, their helpline, I must say they have been very responsive. But I realized I got two distinct impressions that first of all, there is no game plan. Water comes, they try to clear the drain, they take the sludge out, then they take the garbage out. They don't have idea of connectivity of the drain. And secondly, because there's no drainage map, so they are basically clueless. They're clueless. Yes, they're clueless. Your Honor, this is where I stay. This is the fourth byline, Bauchistapur. On the left is the picture, they enter from the main road, that's the last gate side. So the far end is the water starts accumulating. This is the far end on the right hand side, where I get up to knee deep water. There was no flooding till 2020 in this area. This is the post-COVID. So, Your Honor, I did a bit of drainage gradient survey on my own by using Google imagery. I'll go straight to the Google image to get a clear idea. Your Honor, I'm just highlighting this U-shaped lane. This is the lane where I stay, the fourth byline, Bauchistapur. And we'll now go for see the elevation, gradient elevation map. Your Honor, the road goes up to this point and then turns, it makes a U-turn. If you see the red line on the left-hand side, it is existing natural nala. There is no connectivity of this drain to this nala. I will just connect this now. Now I'm just showing this is the gradient of the road. This is where it starts from the entry point. As you can see, the higher elevation, and then it falls. It falls, and this is the point where the drain ends. So what's happening? If you mark this area, this water should have flown further west towards the existing drainage. Since there the road ends, the house is there right on the gradient. We cannot lay a nala there. So the entire water is stagnating there. That is the problem. Had there been the nala, if the drain was connecting up to that Lakshmijan, which is actually old Bhagirathi River, the water naturally flowed. The entire story of Bauchistapur flooding is primarily because none of the drains, excepting one, which is very narrow, is connected to the existing natural drainage. The biggest problem, again, I would like to reiterate is that our drains are not laid along the gradient, and more importantly, there is no connection with the existing drainage. That's why there's no way for the water to flow out. Now they're pumping water from here and there. This is a view of survey area. Similar story. I will not repeat the same thing. Again, there's a gradient is there. No connectivity with the Lakshmijan and the west. Now, what's the way out? We have to lay drains along gradient, but we need the technical input to guidance as to how to go about it. A good way is to use a drone technology. Is very, very widely used nowadays. There are two technologies, one called digital terrain modeling, digital surface modeling. We tell exactly where the problem lies. We just have to follow that map. The software will tell you how to lay the drains, how to go about it. We have to either reorient our existing drains or lay new drains. Now, this is one which says that the basic thing, the green is low elevation, mid elevation. It is just a terrain model. This is what I like to bring attention to the code. This is the drainage, existing drainage, which is by using this DSM, surface modeling. There are three codes here, slightly fine. One in blue, one in green, one in red. The blue is what existing, the water is now stagnating. Green is what, if the whatever had opportunity, the water will flow along the green lines. And the green lines finally go and join to a red line. So the drainage should be such that we have to ensure connectivity of the existing blue lines because the drains are already there. We cannot break them. The blue lines should, there should be drains connecting to the green lines connecting to the red lines. Water will flow automatically. To a large extent, this should solve the problem. This is just one approach.
This is for one area.
Pardon?
This is only for one area.
This is only my area.
Versus poor area.
Is my area.
What about the whole other areas of the city which are facing this?
They have to do a similar study because this I did at my own end because I stay in this area. So I engaged one firm who very much the firm is from Assam based. So they did it for me. So then I got to get an idea. How to solve the problem? We need to know how to drains to be laid. The technology is there, Your Honor.
That is there, yes.
Yes. Now we have this Guwahati Water Preservation and Conservation Act 2008, amended 2010, and we have now another bill coming up 2024. There are certain inconsistencies because it relates to the water bodies. I just thought I'll bring the notice of the Honorable Court. Now, this act aims to provide preservation, protection, conservation, regulation, maintenance, etc. Very well-meaning intentions, but it says that and convert them into ecotourism recreation centers. The intent of the act is not to conserve. The intent of the act seems to be to conserve for ecotourism to suit ecological balance. What I feel understand, I am from forestry background. I feel understand that how an ecotourism recreation center can ensure ecological balance. I don't know, how this wording came into the act. There are 4 water bodies, Silsako, Deeporville, so and so, before. It mentions the boundaries, no area. So we do not know what's the area. Very interestingly, the Deeporville, Your Honor, is the biggest water body, wetland, in Guwahati city, spreading over nearly 40 square kilometers. Now, in that act, both 8 and 2010, in the schedule, it doesn't mention Deeporville, it mentions near Deeporville. Now, Your Honor, I fail to understand which is the water body they're referring to. Is it Deeporville or is it near Deeporville? Because near Deeporville, I don't know, there's no other water body. There's only Deeporville. So I don't know why this anomaly is there in that act. I'm just bringing the notice of this Honorable Court. Same inconsistency continues in the 2024 bill as well. I'm going to main part now. In my assessment, whatever my limited knowledge assessment, I have made 3 categories: immediate, short-term, long-term. 6 months, it depends upon the authorities to this thing. First, we need to restore the original course of Binary River from Bachista to Beltana market. That is by removing the sluices. Then, second, we need to clear the entire stretch of Bondajan, which is the outlet from Silsako to Brahmaputra. This needs to be done. This thing. I am not speaking about the dead river, that's already gone. We need to widen the Bahini for Rukmini Gaon to the Assam state too, because there the maximum water is flowing out. But Rukmini Gaon is not flooding very badly. Very importantly, Your Honor, I will stress, an umpteen number of times, we need to have single agency to manage Guwahati drainage. We don't want GMC, GMDA, Town Country Planning, PWD, Guwahati Disaster Management Authority, all these multi-agencies coming and attending the same problem, and never going to solve the problem. It has to be one single body, and I say that body or agency should report either to the Office of Chief Minister of Assam or Chief Secretary. Otherwise, I don't think Guwahati will be livable city next 10 years. That's my fear. I'm from Guwahati. I have to stay in this city of mine. Your Honor, the provisions of 74th Amendment Act, that is decentralization, has not been, I believe, extended to civic this administration. Short term, we need to prepare a map. We need at least 1 year. By engaging, yes, the government of Assam has now engaged external agency from the Netherlands. Very important, we need local experts because they only know what the problem. We must take action to remove encroachments from the Bahini river course. The river courses don't have legal notification. That's big problem. It's not too late to issue a legal notification of river courses so that at least henceforth, if someone wants to take a matter to the court or to fight it out, he or she can do justice. Again, inlet outlets for all these things should be rejuvenated by clearing. Exit drains to be reoriented along the gradient. Otherwise, there's no point talking about tackling flooding. We have to trap runoff from hills to a proper SMS activity, that is soil moisture conservation activities, tree planting, well planned. Long term, we need to connect all the drains to the existing natural drainage. Eventually, that's the best way out. As I said, drains to be laid only along the gradient. Pumping stations. Pumping station is now going to become a permanent feature of Guwahati. Now, what's happened? Because drainage was not planned, there are certain areas in the city which are becoming bowls, isolated bowls. Water finally go and collect there. So we have to install pumping stations and have to drain to stormwater drains or overhead pipes. I don't know, the concerned authorities may best decide. But pumping stations is now a technique we'll have to now adopt in a large scale. Now, Netherlands, this form from Netherlands has come. I like to just quickly highlight. Netherlands is known for two important things. One is windmills, other is tulips. Now, the windmills has the origin because Netherlands is a country which lies below sea level. Nearly half of the country is below sea level. They have history of flooding, the history of loss of life and property damage in that country also. Now, in the last century or so back, they had to find some ways to drain excess water out. Electricity was not available in excess in those days. So what they did, they started constructing windmills. Each of the windmills will have a system of, the local system of taking water out. There were canals. So the water will be taken out from the flooded canal, put another canal. That's how the windmills had origin in Netherlands. Now, Netherlands, they don't depend on windmills anymore. They have got very sophisticated system of pumping stations. We have to remove the encroachments. We have to widen the stretch of the Khanapara Canal because there are a lot of water coming from Meghalaya. This is one solution I was offering. Water from Meghalaya is entering Khanapara near Ganesh Mandir. What we can do is that along the Meghalaya border, first we lay a wide drain. Once it reaches Khanapara, lay a stormwater drain. The stormwater drain can go and straight away it can join to Basista River near ISBT complex. The entire Meghalaya water or a majority of water can be diverted through this stormwater drain to flow into Basista without flowing inside the city. From Basista, it actually goes to Depot Bill, and from Depot it goes to Brahmaputra. That way we can, I think we can to Khanadan, yeah, to Khanadan. From Depot Bill to Brahmaputra through the Khanadan canal. That's about 3-kilometer canal. Yeah. It's all, Your Honor. I'm hoping that whatever I suggested, if it is
Useful for this state also.
3 months, I've been
Appreciate
actually.
your efforts.
Yes. This is my rickshawala. So when this is my lane, so I was going around in this rickshaw, all the lanes. Your Honor, the total length of the natural drainage in Guwahati is roughly 100 kilometers. I have personally perambulated each of the meter 100 kilometers. So I know I travel from the source to the sink. So whatever presented today, Your Honor, is based on primary data. It's based on personal experience. So I am not a qualified engineer, but I have tried my best to present.
We
Solution.
appreciate your effort.
Thank you. Thank you, Honor.
Mr.
Milord, what Mr. Borua has presented in the booklet form also we have prepared for a lordship's kind perusal. Long copy I've handed over one copy to the Advocate General also, Milord.
Yes.
And my only submission is, Milord, I hope Mr. Borua has put in a lot of effort.
Yeah, no doubt.
And maybe the government of the day would like to take the suggestions, Milord.
Sure.
I've already
The
spoken
government
to
has
Learned
already
Advocate
invited.
General. He has also,
In fact, government has already invited suggestions from
Yes.
these suggestions are welcome from any from any person or any agency or whatever it may be. Mr. Secretary,
there is two more aspects, Milord.
yeah,
that encroachment in the hill cutting, and my lord, this, I mean, market being set up everywhere. That is an
That is a
aspect, my lord.
combined encroachment, setting
Yes.
up of markets.
Yes, yes.
And then this drainage system, these are all the combined.
Let us do a start, my lord, so
Yes.
that tomorrow we have a solution.
Yes, that's right. So Mr. Sekia, now till this date, for the government has.
Yes, Lordship, I'll definitely, but I am very thankful that my learned friends, that the gentleman has very correctly said.
Yeah.
We have lost the plot in the 70s and 80s. We have lost, so that is history. Now what we can do, absolutely he is correct that we do not have a comprehensive drainage master plan.
And one agency,
One agency, so
that is also very.
that will come later, little bit later, because we'll have to, that is a very correct suggestion also. In fact, we are contemplating that. So first, let me place this. You can get here. As Mr. Borua has said that Netherlands has that history of problem because it is located below the sea level. So we have also engaged an agency called
George Peters.
Hascong DHB Consulting Private Limited. On 21st of August, agreement has been executed between the government of Assam and them for consultancy service for preparation of GIS-based comprehensive drainage master plan and detailed project report for Guwahati city, India. Work order was also issued on the same date. So the time of completion, Lordship will kindly note 9 months. And the work is preparation of GIS-based comprehensive drainage master plan, and what has been just suggested, we have already in job. And now the 12th September's letter, Lordship will kindly take the second letter. They have submitted. With reference to the subject, we are pleased to update you the progress of Inception report for Guwahati Drainage Master Plan. The report will broadly contain introduction of the project background, objective and scope of work, project area, approach and methodology, scope of topographical survey and ground investigation, including preliminary assessment outcomes, quality assurance plan, project schedule, milestone, deliverables, and work plan. To this Lordship, they were given the 28th, that means 2 days ago, the last date for submission of the Inception report. Just now I have received the Inception report. It is very detailed. It has considered everything for last three decades area. What are the problems, including USTM area, Khanapara area. These are new areas. My learned friend, the Borua, has just said that till 4 years ago, there was no problem in that because of USTM and other hill cutting in that area. Once we leave Khanapara and proceed towards Jorabat, Lordship, that area is a major cause of concern. We have other concerns, those areas we have already mitigated, like earlier Santipur area. That was one of the area where we had major floods. But that is a thing of the past now. For last 10-15 years, there is no flood in Santipur area. Or the other areas near the basin of Horolu. We don't have now problem in Lasit Nagar area, Rehabar area. My friend will agree. These areas we have mitigated. Maybe because of various, we have broadened the Horolu channel also. There are guard walls on each side. There is no scope for further encroachment, no dumping, timely clearing of the roads. And those pump sets were also placed there. So new areas are coming up, old areas are clearly problems are being solved. So now we are working on these Lordship, that comprehensive master plan. They will definitely give, and I would like to submit this Inception report also. That has very clearly indicated, I have just gone through it, but I have not printed properly right now. It was given day before yesterday. In a affidavit, I will place it because most of the areas or categories which my learned friends, client, Mr. Borua has submitted, Lordship, those are part of this also. Okay. And we will also request him to be a part of our team. Maybe he can get in touch with Chief Secretary or the authorities, Lordship. I'll facilitate that. If he has some inputs, that will also be beneficial.
That would be useful.
In fact, we have issued a public notice also requesting people to give their opinions and inputs.
Have you received some suggestions from
Lordship,
public at large?
this Inception report, in my humble submission, Lordship, it's a very extensive one. It covers every area. Now, if the study is properly done there, and if it is properly implemented thereafter, Lordship, I think that will at least 80% problem will be solved. Some problems will always be there because of the topography.
New problems will come and.
New problems will come, we have to, as it
Measures for
comes.
that. No doubt.
Because some areas, because of the flow of water from the hills, lordships, that area will definitely, earlier we have water logging for 2 days. Now we are having water logging for 1 hour. That way we are diminishing the problem. But new area, because of that Khanapara area, that has given a very bad highlight on the performance of the Guwahati city lordship. But that was a problem which cannot be attributed to us. In that case, another state is involved. So Article 131 will come, lordship.
That's right. Okay. That's all, Mandala. Yes. Pursuant to the direction given by this court, pursuant to the time granted by this court, Mr. D. Sekia, learned.
Well, with your lordship's kind permission, I'm just taking leave.
Yeah.
My friend will do that.
Learned Advocate General has informed this court that the Guwahati Metropolitan Development Authority, by the order dated 21st of August 2024, has engaged one Haskoning DHC Consulting Private Limited, a consultancy services for preparation of GIS-based comprehensive drainage master plan and detailed project report for Guwahati city. Work order has also been issued to the said agency on the very same day, and the agency has submitted a Inception report for Guwahati master drainage plan, which contains introduction with the project background, objectives and scope of work, second project area, approach and methodology, scope of topographical survey and ground investigation, including preliminary assessment outcomes, next quality assurance plan, and next project schedule, milestone/deliverables and work plan. Full stop. It is informed by Mr. Sekia that the consultancy agency, the above referred consultancy agency, is to prepare the comprehensive drainage master plan within 9 months from the date of issuance of work order. Full stop. It is submitted that the Inception report submitted by the said agency would be placed before this court by way of filing an additional affidavit by the next date of hearing. Full stop. Mr. K. N. Chaudhary, amicus curiae, has also made certain valuable suggestions. Mr. Akash T. Barua, IUFS retired, has also submitted a PowerPoint presentation with the PowerPoint presentation highlighting the reasons for the flooding in the Guwahati city, and has also proposed some solutions which can be taken into consideration for tackling the problem of flooding in the Guwahati city. We appreciate the efforts of Mr. Barua, who has submitted a comprehensive report. Learned Advocate General, Mr. Sekia, has submitted that the state is ready to take services of Mr. Barua for tackling the problem, and has assured this court that the state government that he will facilitate that suggestions of Mr. Barua be taken into consideration at the appropriate level by including him in the team of the state, in the team of the state, which is.
Lord, may I say something? Including in the team, maybe we have given it to them, Lordship. His input can be considered. That up to that level, I am considering, Lordship.
Okay, by considering the inputs suggested by Mr. Barua. Full stop. Having considered the above, we are of the view that the state government is serious in tackling the problem of waterlogging and flooding in the Guwahati area. And we hope that the effective measures shall be taken at the earliest. So the earliest to tackle the problem, problem. Full stop. When next month,
Let's come after vacation, after 4 weeks.
is this PIL petition on 29th of October,
Lordship.
29th of October 2024. By that time, Mr. Sekia may, Learned Advocate General, Mr. Sekia may furnish the progress in the progress report before this court. Full stop.
Highly
Thank you,
object.
Mr. Barua.
Thank you.
Thanks a lot. And the Learned AG has assured that your services, they'll certainly use your services, please.
Thank you, Mr. I'll be in touch.
Item 6.
May I please, your Lordship? Lordship. May I please, your Lordship?
Just yes, Mr.
May I please, your Lordship? Lordship, on last occasion, that is on 25/6/2024.
Yeah.
The Lordship had posed the query regarding the maintainability of this PIL, Lordship.
Yeah.
So, Lordship, I will try to convince your Lordship that PIL is maintainable in the present form, Lordship.
So in fact, the problem is that the PIL, you are saying that some of the people are aggrieved by this, whatever the inclusion or exclusion of the panchayat from this panchayat area to, or inclusion in the municipal area.
Lordship.
But what we feel that it's a individual, the persons who are having some problem, they can approach the court by individually, not by way of filing an PIL. You can't say that all the persons of the this area are aggrieved by that. Many of the persons are agreeing to that. That's why only a very similar petition we have already disposed of, while observing that if the persons have any grievance, they can very well raise their grievance individually. That is there, that PIL number 37 of the 2000.
Lordship, I was present on that day, Lordship.
Dispose this for 125/6.
Lordship.
24 itself.
I was present, Lordship.
Here you are present, then,
I was present, Lordship, and I have sought time for satisfying your Lordship on maintainability.
sir, yeah, just let us know.
Lordship,
Then
here,
tomorrow, suppose some persons will come and say that we are not agreed by this and why you have changed this, then who is going to decide that?
Lordship, my contention is that, Lordship,
Your
already,
contention is that this municipal area is so far and whatever the 2 or 3 contentions you have mainly raised.
it is not only regarding the Lordship, the formation of the municipal board. It is regarding the way the municipal board has been formed, first of all, Lordship.
What's the way?
Lordship, the initially Lordship will only come to the notification, there's a 39/2019, Lordship.
Fine.
Lordship will find that page 41, annexure 1, Lordship.
Yes,
Lordship, this notification was published on
Yeah.
39/2019,
fine,
whereby Lordship, the 8 words were initially created, including 8 words.
fine.
8 words were initially created, Lordship, including 5 villages. And subsequent thereto, Lordship, there comes the another notification,
Fine.
which was published on 9/2/2022, Lordship.
Yes,
Here, Lordship, without giving any further notification, as per mandated by section 4 of the Municipal Act, 2 more words were created, suo motu. And subsequently, elections were conducted in 10 wards, Lordship, only in order to fulfill the criteria mentioned in section 11 of the Assam Municipal Act, Lordship. Because as per section 11,
that's right, that they have not followed the procedure.
Lordship,
That's right, we understand that. And maybe that may be a good ground for challenge, but why PIL? Why the people who are aggrieved, they are not able to approach the court? You have to mention it.
we have filed a PIL because, Lordship, there are people around 6,000, more than 6,000 people
So
who have,
all these 6,000 people are aggrieved by this?
Lordship, they have filed a representation, Lordship.
It's a representation, all 6,000 people?
Lordship, it is there, part of the record, Lordship.
6,000 people have filed one representation. that we
Representation,
are
Lordship,
aggrieved.
part of the record, Lordship. It is the part of the record, Lordship.
Who is authenticated that?
Lordship will find the representation. Annexure 6, Lordship,
Yes,
page 139.
one thirty-nine, yeah.
Page 139, and the signature part starts from page 146.
So who is going to authenticate this?
Lordship,
That these are the persons really they are aggrieved.
In the additional affidavit they have filed, my lord, there is a signatory of 200.
200, Lordship.
200 of it.
Because Lordship has put another question as to the authority of the 10 petitioners who have filed this PIL.
Yeah.
So that has been, Lordship, the subsequently one additional
Sir, this
affidavit
is-
has been
in
filed.
fact, this is the problem individually. Suppose you have mentioned this, 1,000 or 2,000 people and another 2,000 are happy with that, then
And Lordship, the practical difficulty is that, Lordship, the 80% of the people residing within the ambit of that municipal board are below poverty line, Lordship.
how?
BPL.
how we say that this 80% of the people are residing at poverty line and these are the, where are those data?
Lordship, we have enclosed all the data, Lordship. BPL list, beneficiary list, Lordship, everything has been enclosed along with the petition, Lordship. Look at the page number, please. Page number 46 to 98, Lordship. One zero seven two and 38. It starts from Lordship page number 46 and continues to page 98, Lordship. Annexure 3, Lordship, page 46. These are a
Yes.
list of the beneficiaries, Lordship, who are
So first of all, you satisfy that this PIL is maintainable because this, you just show us the law on this part. But that's very difficult to maintain this PIL once we have already taken a view in relation to this municipal council. We are not supposed to take a different view.
Lordship, my only humble submission before your Lordship is that if any issue that has
Yes.
been affecting the people at large,
Sir,
The
how will ascertain how it is going to affect? How the people are going to affect with the creation of a municipal area?
municipal area, Lordship, the
What
people,
benefits which you are getting earlier are you are deprived of those benefits? Or how this panchayat is more suitable for the other persons in municipal area is not? Then we should abolish this municipal system. Why should we create a municipality?
no, Lordship,
Ever?
Lordship, the procedure that was supposed to be adopted by the authorities, Lordship.
It is within the domain of the state authorities that which area is to be declared as a municipal area, which area is to be treated as a panchayat area. It is within the domain of
Lordship,
the,
I do agree, Lordship, but it has to be in accordance with the Article 243Q.
yeah, no doubt. And
It's
that's why
smaller-
only if it is not in accordance with the Article 243Q or whatever the provision of the constitution or the law, then any individual can raise this grievance, but not in the case of PIL. It's a different thing. Consider.
Moreover, Lordship, the people residing in other two wards,
Yeah.
who are the residents of the ward number 9 and 10, which are subsequently created, they have not even availed any opportunity to object to that effect, Lordship, as per section 5 of the Act,
Why they have not availed?
because no notification was published prior to inducting section, ward number
You can
9
raise
and 10.
all these, whatever the illegalities have been committed, you can very well raise in the individual capacity and not in the case of PIL. Look here. Heard the counsel to the petitioner as well as the counsel for the respondent state. This PIL petition is filed by the petitioner being agreed with the action of the respondent, whereby the area of which Gram Panchayat?
Lordship, it is Sipazar municipal board.
Area of Sipazar Gram Panchayat? No.
Sipazar municipal board, Lordship.
Which area of the Gram Panchayat is included in this Sipazar?
There were different Gram Panchayat, Lordship, because there were 6 villages altogether.
Whereby the area of certain Gram Panchayats is included in the Sipazar municipal board. Full stop. The PIL petitioners have raised grievance of inclusion of the panchayat areas in the Sipazar town, Sipazar municipal board.
Municipal board.
Full stop. Prima facie, we are of the view that if any resident / residents of the above referred Gram Panchayat is / are aggrieved by the inclusion of area in those Gram Panchayat in the area of Sipazar municipal board, they can very well approach in his their individual capacity by availing appropriate remedies, and for that PIL is not maintainable. Full stop. Learned counsel for the petitioner has attempted to convince us that the PIL is very much maintainable. However, we have already disposed of a PIL number 3/2017, 37/2023 and ordered with the 25/6/2024 of similar nature, while granting liberty to the individuals to challenge the action of the state government of inclusion of certain Gram Panchayat areas in the municipal board area. Hence, we are not inclined to entertain this PIL. However, the petitioners or other villagers of the panchayat areas are at liberty to raise their grievance by filing appropriate proceedings in their individual capacity.
Item number 8.
Unserved respondent 1 to 5, not 1 to 15.
5 to 15 answer. In this respect, if I may pray before my lord, that it can be served through the respondent department number 4, because in my lord, some of the persons must have been transferred meanwhile, my lord. So if we can.
We'll await return of notice. Let us see what.
Meet me, my lord, as my lord is.
Return of notice of respondent number 1 to 15 for 4 more weeks.
Highly obliged.
Item number 9.
Respondent number 1,
What should appears the respondent number 1 is still not being served, your lord.
not served. Will await.
We'll await, and lordship may also, lordship has already permitted, we'd like to take lordship, Dusty.
Fresh steps, okay. The notices upon the respondent number 1 has not been served since long. Let counsel for the appellant may take fresh steps for service of notice upon the respondent number 1 through registered AD and Dusty lordship. On taking such steps, the notice is issued to the respondent number and return number 6 weeks.
Item 10.
May it please, my lord.
No fresh steps.
My lord, I apologize, my lord. There is a request on my part, my lord. If I may be permitted to take dusty steps, if my lord would.
We have already ordered for that, sir.
My lord, dusty service, my lord, what has happened, my lord? We have-
Registered post AD.
My lord, we have served AD service upon them from quite some time. There is an observation by this court also, order. Since a long time it has been taken, but it has not reached them. So if I may be permitted to take dusty. Copies are also. Notice also. Also, the notice is. Government of private.
You were not party before the London single judge.
No, my lord.
So then you should have filed an application, the application seeking leave to file this appeal. How can you directly file appeal without seeking leave?
My lord.
This is the writ appeal.
Yes, my lord.
Writ appeal, you were not party before the London single
my-
judge.
No, my.
Then you should have moved an application seeking leave to challenge this order. Without seeking leave, how can you maintain this writ appeal? Until and unless this court grants you the leave, how can you challenge that?
My lord, I may be permitted. I seek liberty from this honorable court.
And this application is for
My lord, condonation of.
condonation of the. Okay. The notice upon the respondent number 7 remain unserved. It is noticed that the applicant, that the applicant has filed the connected writ appeal with the delay and was condoning the delay, the IA number 708/2024 is filed. However, the applicant was not party respondent before the learned single judge. In writ petition number 5489/2022, which has been disposed of, wide order dated 24/8/2022. Stop. The applicant has not moved any application seeking leave of this court to prefer an appeal against the order dated 24/8/2022 passed by the learned single judge. Learned counsel for the applicant prays for and granted time to move appropriate application seeking leave to file appeal from this court list after 4 weeks. Yes.
Deeply obliged.
Item number 11.
Lordship, in this case, I'm appearing for ONGC.
May I please, Your Lordship.
There is a leave.
My lord, by this application, my lord, I am seeking a leave of this court, my lord, allowing me to, my lord, prefer an appeal. My lord, in the writ proceeding, my lord, I was not a party to that. And the fact is this, my lord, that ONGC has invited tender, my lord, for hiring 8 numbers of vehicles, water tankers, my lord. And accordingly, we being a L1, my lord, we have been awarded a contract on 4/10, my lord, 2023, my lord. On the same date, my lord, and the writ petitioner have preferred the writ petition, my lord. And there are the orders by which it has been said that no further process may be done by the ONGC, my lord. But we have already been given the letter of awards, my lord. Now, in virtue of that, we have placed our vehicle, my lord, 5 vehicles out of 8 vehicles, my lord. The ONGC have kept 3 vehicles for the person who has preferred the writ petition, and 5 we have been have been awarded the contract. In the writ proceeding, my lord, they have come with an IA application saying that they have awarded the contract to this petitioners, my lord, petitioners, my lord, applicant, my lord. Now, they have taken any steps, my lord, to incorporate it as a respondent. Because we are the party.
The single judge has passed the order.
My lord, without giving an opposite, but interestingly, IOC has made a party there on the request by the writ petitioner, my lord. And we have not been. They have written in their application, my lord. If your lordship kindly see the IA application, they have said that they have already, my lord, awarded a contract to us. Their vehicle has been there. We have taken a loan from the bank, my lord. We have placed and it's still running on, my lord. If your lordship will kindly see affidavit, my lord, their affidavit, my lord, at page, my lord, 441, my lord. That is their, my lord, affidavit, my lord, by which they have in the writ appeal page 441, my lord. On second volume, yes, my lord. Second volume. The paragraph, my lord, paragraph 17, what they stated, my lord, I'll not the entire paragraph.
Reply by whom?
My lord,
This is the reply by whom?
my lord, that is a reply by ONGC, my lord.
ONGC.
ONGC, and in fact, my lord, if your lordship kindly see their IA applications by the writ petitioner, my lord, that is that page, my lord. $347, my lord. My lord, the writ petitioner have filed.
Yes, anybody is writing.
I'm appearing for ONGC. We are filing the affidavit. 10 days time was granted. So we are filing it today, lordship.
Hey, do you have any objection seeking?
Yes, we have objection, lordship, because there is a delay and lecture subsequent tender is at the final position, lordship. So we have already.
ONGC, why I should suffer, my lord?
That is on
By
first.
what time you will file the contract?
Today. In fact, at 10:30 it was filed, in fact.
Thursday?
My lord, because 38 is, they have floated a tender, my lord. And
Thursday only.
my lord,
Thursday.
Thursday,
Doing it on Thursday,
my lord.
Thursday.
Highly obliged.
Mr. Sekia, then council appearing for the
In both, we have filed the affidavit.
ONGC
In both. One is delay contract, one is leave.
submitted that he is going to file a reply to to both the IAs during the course of the day. List after so on. List on Friday,
Highly obliged.
Thursday, my lord.
sorry, Thursday.
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 I'm obliged, my lord.
Yes.
Item 12 and 13.
In these two appeals, which are analogous manner against the same judgment and order passed by the answering major, the respondent in the writ appeal number 185 of 2017 And it expired and we filed an application for substituting him by his legal
He's
heirs.
appearing for the other side.
I'm for the respondent, private respondent.
Do you have any objection?
No.
In substitution?
No.
There are two applications.
Yes, one is for conversion delay, my lord, as such.
One, so first we'll, this. And what about the other respondents?
Other respondents are there, madam.
Notices have been issued? to
Yes,
them
yes,
or
yes, madam. In fact, the council has appeared for all the respondents.
who is appearing for the?
Mr. Chamua is appearing for the
I'm
respondent.
on behalf of private respondent, only private respondent.
They are appearing for all the.
All the private respondents means respondent number 1 to
1 to 17.
1 to 17.
17.
18, who is appearing for 18?
18 I am also.
1 to 18 you are appearing and 19,
19, 20,
20,
that of company.
what about 26, up to 26? There are some, this Seri Infrastructure Finance Limited, private party is also there. Delay condonation का देना। आइए delay condonation।
One of the API legal. API
আমি নাই দেখা, আমি private case এর অনেক
না এই API অন্তর আমার okay.
Then the respondents are. ये 2935. There is no delay. And what this 39 year is another. 2935 is the IA for substitution.
Well, the numbers are
295.
2935, yes, ma'am.
So for that purpose, you are appearing for the private respondent of 1 to 18, but what about the others? The appeal, the others are represented.
Others can appear going and they are the
This
private.
appeal number 185 mein others are represented or not?
It is one.
185.
Look here, this IA number so and so, IA number 2935/2024 is preferred on behalf of the applicants with a prayer to substitute the legal representatives of respondent number 1 who has expired on which date?
18/12/2023.
18/12/2023. Full stop. Having gone through the contents of the application, we deem it appropriate to allow the same. The IA number so and so is allowed. The legal representatives of respondent number 1 be taken on record. Amended cost title be filed within a period of 1 week. You are appearing for
All the
legal representatives.
lordship.
Mr. So and so is appearing on behalf of the legal representatives of respondent number 1. Hence, no formal notice is required to be issued. List after puja vacation.
Both the IAs are disposed of.
Which IA?
The other IA for condition also may be disposed.
Condonation ki IA is not there here. There is no IA in this 185/2017 for condonation. There is no IA. IE number 7 is disposed of.
Vale, deeply obliged.
Item 14.
May I please your lordship?
Okay.
May I please your lordship?
Yeah.
Actually, before my learned senior colleagues start lordship, we have got instruction to appear on behalf of all the private respondent lordship.
All the private respondents.
Yes, lordship. Lordship, 10 days time may be granted to file our response lordship. Today morning, we have received the brief lord.
And what about the other respondents?
Other lordship, government is the particular.
All of the different. What about second? Look here, Mr. So-and-so put an appearance on behalf of respondent number 3 to 6. Full stop. Other respondents are already represented. Full stop. The council appearing for the respondent number 3 to 6 place some time to file counter to the petition. Let's start.
Today is the date fixed for consideration of the interim order.
Lordship may kindly consider it on the next date, lordship.
After the, Puja
Lordship may kindly fix a date if possible.
date, he will give you the date. Yes.
2310.
Highly obliged, lordship.
Item 15 for admission.
Admit. Notice. You are appearing for?
Respondent 2 and 3.
Who are the respondent number 2 and 3? The election,
State of issue.
Huh?
State of issue.
State of. Admit issue notice. Mr. So-and-so, accept notice on behalf of the respondent number 2, 3 and 4.
2 and 3, lordship.
Why? State Election Commission.
Election commission.
Election commission cannot be represented.
Okay, maybe Lord will have to take steps.
One is the private.
One is the party,
Private.
One is the party.
the petitioner before the learned.
Mr. So-and-so accept notice on behalf of the respondent number 2 and 3. Let notices be issued to the respondent number 1, 4, 5, 6, and 7. Returnable 8 weeks. In the meantime, effect and operation of the order dated so-and-so. Effect and operation of the order dated
Lord 22/8.
22/8/2024 passed by the learned single judge. The petition number 131/2022 shall remain stay.
Lord, the judgment which the learned single judge has relied upon, that was in a different context altogether. There, my lord, section 81 limitation.
For the purpose of corrupt practice, to prove the charge of corrupt practice, there must be some evidence. For that reason that they.
So therefore,
People got
329 is a
influenced.
bar. Therefore, 329 is a bar.
People got influenced by that non-disclosure of this fact or wrong disclosure of this fact.
No, but what I was trying to submit, my lord, that judgment which the learned single judge relied upon, that was a case, my lord, the time prescribed under section 81 of the ROP Act was over. Then, my lord, he earned disqualification under article 191 and 193 before even election, where the honorable court gave, Supreme Court gave an illustration. Supposing a foreigner contests an election, he wins, 226 cannot be invoked. It was in that context. But it is not a proposition of law.
2011.
Deep level.
2011. Item 16.
May I please, my lord? My lord, the respondent, my lord, was initially, my lord, appointed as a good guard, my lord. And thereafter, my lord, in terms of the options invited, my lord, will take page 53.
Yes,
Page 53, my lord, I think, my lord, it is legible, my lord.
yeah, not legible.
My lord, I'll give the copy, my lord, I think. My lord.
Yeah.
By this letter, my lord, the railway, my lord, invited options from the following categories, my lord, that is good guards, senior good guards, male pass guard, my lord, and respectively. So, my lord, here the options were invited from the respondent to apply for the post of the section controller, my lord, which is a selection post. And my lord, accordingly, the petitioner, my lord, made an application in terms of the option which was sought by the railway. And my lord, he applied for the post of section controller on 26/3/2015.
Uh.
My lord, after that, my lord, he was impaneled for the post of section controller on 29/8/2015. And thereafter, my lord, he underwent training for the said post, and subsequently, my lord, at page 58, my lord, that is on 27/10/2016, my lord, he was promoted to the post of section controller.
Notice returnable. Registered AG Dasti.
My lord, may I pray for a stay, my lord, till the returnable date?
Till here and then.
My lord. Objection.
No.
Item 17.
My lord,
There is
another
another
matter, lordship has already fixed it on a date after.
So Mr. Mishra is appearing. again.
Yes. My lord, I had a small prayer, my lord. If your lordship would kindly come to, in the other case, the interim order which was prayed for was not to enforce the, demand.
Yeah.
But our prayer is not that. Our prayer is, my lord, if your lordship would kindly come to page 80, what is being permitted by the rule is page 80.
Yeah.
If your lordships will kindly come to sub rule 7.
Yes.
If a challan is due beyond the time period specified in sub rule 5, except in case of offense instituted for prosecution by a court, then application with respect to license of offender or registration of motor vehicle, as the case may be mentioned in the challan, shall not be processed by the licensing or registering authority as except application relating to permit, fitness, tax, etc. So we are praying the Lord, at least our pollution control and fitness part, that should be permitted, my Lord.
The
What
fitness, except application relating to permit fitness is already permitted now.
No, that's why, man, they're not doing.
But
That is the problem. On
that
the
is
plea
there.
that we have not paid the money or the fine, They are, my lord, withholding, issuing a pollution control certificate and fitness. Others is okay, my lord. Its rules provide, let your lordships will decide.
Rule 7 is very clear, sir.
Yes.
Why you are not, this fitness certificate you are not
Today I
granted?
have entered appearance since I was expecting a notice would be only. So let me take instructions. What is
Only-
the ground realities? Then I'll make my submission. Let it come
3rd of October.
third.
Mr. Sekia, in appearance on behalf of all the respondents, copy of the writ petition be supplied to him during the course of the day. List on 3rd of October 2024.
For interim, consideration of interim order, my lord.
Let him come with this understanding we are giving
Yes,
this.
Highly obliged.
Deeply obliged.
Item 18 and 19.
May I please, Lord? My lord, in this appeal, my lord, this appellant, my lord, claiming the all pension scheme, my lord, as per their initial date of appointment in 1999. But that was, my lord, denied him by the learned single judgment. My lord, already in the connected matter, my lord, notice has been issued, my lord. So this,
Well, you accepted that appointment, wherein there is a stipulation that all the previous appointments would be treated as cancelled. And how can you turn back and say,
my lord, that,
grant me the benefit of that?
my lord, that order was passed initially, my lord, in 1999, when we were initially appointed, my lord. And illegally, my lord, our appointment has been.
While accommodating you as assistant teachers, this
My-
was the specific order and you have accepted that.
Yes,
There
my
was
lord.
wrong in that.
But my lord, that order has been passed up as per the judgment of this honorable court, my lord, by the order of division bench, my lord, we have been reappointed. And my lord, that order has.
Where with the stipulation
my
that
lord, we are
all the
claiming-
previous, you'll not.
No, but that is their order, my lord, by the respondent, my lord, issued by the respondent. We are claiming from 1999.
That was the order, the 2009, and you kept quiet for up to the 2000, this filing of writ petition up to 2023. You accepted that.
My lord, in that litigation, my lord, our contention was there. Yes, my lord, that is specifically not challenged. But my lord, the same, my lord, similarly situated persons, my lord, were considered by this honorable court, my lord.
That's
My lord, the person, my lord, who were selected and appointed from the same
while
select list.
accepting their appointments dated so and so, the petitioners have also accepted the side specific observation by the DE dated so and so regarding their appointment and adjustment made earlier against the selection under the secretary so and so, treated them as cancelled. And you had accepted that.
That was a consequent order, my lord. Initially, my lord, we have challenged our, my lord, cancellation of our appointment, my lord. We are initially appointed in 1999.
Similar, may I notice
Yes, yes, my lord.
when, what is the number?
My lord, item number 19, my lord.
They were not
similar. Out of, my lord, same judgment, my lord.
141 of 20.
That was heavy judgment. No, no. It will put it. It will put it. Remember, Uh, 131. 131.
We have not issued the notice. We have simply noted your submission that another rate appeal is there. We have not issued notices. to
No,
the
no, in this, my lord, in this appeal, my lord, no notice is issued till date, my lord. In the connected matter, my lord. Item number 19, my lord.
Notice till, yeah, okay.
Appeal number, my lord, 131/24. Item number 19, my lord.
Yeah. Taking into consideration that in identical appeal, rate appeal number 131/2024, notices have been issued. We also deem it appropriate to issue notice in this rate appeal. Mr. Majumdar accepts notice on behalf of all the respondents. This rate appeal along with writ appeal number 131 of 2024. After 8 weeks.
Published.
Item 21,
My lord, I have not filed my affidavit, but my prayer is that matter may be fixed for a hearing. Because on this point, exactly other judgments are there. By our earlier division bench, I will place some judgment.
You need not to file any affidavit.
No, my lord, I am not filing anything. My lord, may I submit, my lord? Let me place the judgment in the form of an affidavit. 1 week time I will take. In the form of an affidavit, I will submit all the judgment. 1 week time.
On the very same issue?
On the very same issue. Because the tribunal has dismissed the.
Let him file, Lordship.
Tribunal has dismissed the review petition.
The review is dismissed on the ground of.
No, we are not on the review. Can we get Mr. So for private respondent please some time to file counter to the petition, time period for his granted. Let's go on so interim order to continue till next 8 weeks.
All right.
Okay.
item 22 and 23,
Retired,
May it please your lordship.
retired.
No, of course, we can, that was sometime in August. But what I am on today is that, but via media ways, so far as the age dispute was concerned, that I could demonstratively show me that what we had indicated was correct and all records maintain it till date, number one. Number two, so far as the age education qualification is concerned, I tried my level best to get hold of some law which says that prior to coming of course into any act, whatever a venture school had could have any other qualification. I'll leave it to my colleague on the other side to say that they needed some prescribed qualification. For me, no. What we had is at page 61. 61, the headmaster takes a call. So my prayer is, since the other side is out, yeah, all I may pray is that the inequity, what I'm praying, let us take enforcement of law. August, I am out. But she was terminated way earlier. If my lord is pleased to proceed on the premise that her termination is bad in law, although my submission would be the official respondents had placed record to show that she was not there and a conscious decision was taken to terminate her services. That's for them to say. But even if she comes back, let her come back post my retirement. Even if she comes back.
Yes. That's all.
That's all. Paragraph 17 at page 26. Because my only difficulty was what was put against me was age and education qualification. In absence of any prescribed age, I demonstrated, okay, yes. But educational qualification, there will be nothing in the law to suggest that at the point of time relevant 1999, whatever law held the field, they would have prescribed for the post of junior assistant a particular qualification. Me being a matriculate along with typist was well into it. And by the time the new law came in, then that may not be given to retrospectively.
Therefore, my
We consider.
but only paragraph 17 of page 26 may also be taken care of.
Obliged, Lordship.
Wait, sir.
Yes,
My lord. He inducted in the post 2008, not in 99. My learned friend always trying to say he is appointed in 1999. Against which post? Where is that? Every document shows appointed 2008. And he was not qualified, ineligible by age, by qualification. To justify her appointment, subsequent documents manufactured. Everything is clearly
order is.
written in the.
Wait for me. Obliged.
Obliged.
Yes,
Item 26.
This matter was submitted by the outstation council lordship. Perhaps he could not connect the VC link lordship. It's a part of what the matter for that day lordship.
Pursuant to the last order, my lord, I got the instruction that, my lord, that personal hearing was not provided. That's what our record says.
personal hearing was not.
Yes,
provided.
under section 75(4) of the
So
central.
no
case.
opportunity was granted.
Yes, for before the final, my lord, penalty order. But, my lord, a virus of a provision has been put to challenge. So that's a separate issue again, my lord, in the present case.
When the council is able to appear.
Today lordship we could not connect lordship. So
PPL
and another lordship.
After Puja vacation. After Puja. You file in the meantime, you file.
I will file.
Response, yes.
Item 27.
Would be difficult. Yes, Mr.
Maybe.
The problem is same which we have mentioned you earlier. In fact, in the absence of any clarification by the Honorable Supreme Court, it would be very difficult for us to assume the jurisdiction on ourselves. The problem, we have already moved the Honorable Supreme Court for seeking clarification.
Yes, my lord.
Until there is no clarification.
But the problem is that the person is behind.
We understand that, but
Yes.
sir, whatever the directions of the Supreme Court, that is not clear in respect of their jurisdiction. So our predicament, you understand very well.
Yes, my lord.
Yes, we understand your problem also, but what can we do now? And we have moved months before for seeking clarification. That's the whole thing.
But
Some clarification is there certainly. We'd be happy to entertain those bail petitions, but since there is no order, what can we? What's the next date, Mr. in the Supreme Court? Are you aware of that?
Actually, today I missed it, my lord. That's why, my lord, can it be tomorrow, day after tomorrow? Everything, my lord, what happened next date, my lord, I'll provide you a lot.
sorted maybe.
Mr. Mehta put in appearance on behalf of the Guwahati High Court. He placed some time to complete his instructions. List on 3rd of October. Would be convenient. 3rd of.
Item 28.
Well, in this case, reply has been filed, my lord.
Yeah.
That was affidavit deposition filed by respondent number 1. I had filed a reply, my lord.
Yes.
So, my lord, this matter. So, department my lord, after vacation.
Yes.
My lord, department will fix for final hearing after vacation, my lord.
What about the clarification, Mr. Chaudhary? Have you filed your response?
Yes, I filed an affidavit.
You have already filed, and the state has also filed. So what about this, that without the no objection certificate, whether these colleges are offering, private institution offering B Pharma courses or not?
Yes, ma'am. That is-
In fact, that part of it has been delegated to the state authorities.
Yes, what the state?
So far as our affidavit is concerned, we have clarified that my NOC has been issued
That was,
for a particular year. Thereafter, it has been extended. It is
Main
there, but-
grievance raised in the petition is that the
Without
colleges are offering courses without any NOC from the state government.
Right.
But once they have come with this, that the NOC has already been granted, then
that is
Except
all
one-
been issued by a subsequent date, my lord, covering the, my lord, retrospective date, my lord. That is the date, my lord.
the pleadings are complete. The issue raised in this PIL petition is accepted. In respect of the private institutions offering B Pharma courses without the necessary NOC from the state government. Let this PIL petition be listed for final hearing after 10 weeks. After 10 weeks. Yes,
After vacation, my lord.
yeah, after 10 weeks.
Master, Mr.
Yes.
Item 29.
This case, your lordship, before my friend starts, your lordship, the school authorities has filed an affidavit in opposition, your lordship. A copy has not been served on me, your lordship, of that.
That is for them.
For them, your lordship, but what is their stand, your
They are
lordship?
supporting your case or opposing your case.
What they are supporting his case. This is for the first, maybe, your lordship, I have.
Supply them the copy. Yes.
Otherwise, your lordship, it is ready for.
I am ready for a hearing also.
They will hear, but since he is wants to look into the counter affidavit, then
On parts or parts of.
either we order or we will do that. Okay. Have to be the vacation.
Item 31.
Here we have filed affidavit.
Not the.
You have filed affidavit?
Yes.
So the basic challenge here is, my lord, regarding the HRA classification, my lord. The Learned Central Administrative Tribunal has, my lord, granted a classification, my lord, under a particular category, but our contention is that, my lord, the state of Mizoram has never been under the my lord, it has always been under category C, my lord. Sorry, my lord, it is under the B class category. And my lord, I'm sorry, my lord, I'm just.
The petitioner and the government did indeed issue instruction 93, 97 reclassifying as well as C class city.
C class city, sorry. Yes. My lord, since inception, my lord, Mizoram has been under C class city only.
Fine.
It has never been, my lord, fifth pay commission, sixth pay commission. My lord, only the categorization has changed to Z, my lord, but it has always remained under the same category. Now, my lord, the basic, my lord, the state of Mizoram, my lord, was formulated. My lord, the state was formed in the year 20 February 1987.
Yeah.
And thereafter, my lord, the first time when the classification was made, my lord, regarding the HRA allowances for the central government employees in the state of Mizoram, that was, my lord, on 1/3/1991. And my lord, that Ministry of Finance notification is, my lord, at page 306. Page 306, my lord. My lord, page 308, my lord, we'll see. The relevant portion, my lord, is at page 310. Wherein, my lord, the state of Mizoram has been put under category C. And my lord, when the matter was taken before the apex court, my lord, we'll see, my lord, take my lord, page 1.
The decision of this court. The decision of this court to treat the as well as B class, B category. city.
That was, my lord, taken challenge before the Supreme Court, my lord. My lord will take page 126.
Yes,
Page 126, my lord.
yes. What happened?
And the relevant portion, my lord, starts from page 128.
Yeah,
We have thoughtfully considered the submission of the learned counsel. In our view, the direction given by the tribunal which has been confirmed. Manoj, I'm reading from last paragraph. Last paragraph of page 128.
76. We have thoughtfully considered the
Yes,
submission in our view, the direction given by the tribunal which is confirmed by the High Court merely ordains consideration of the cases of being employed for grant of fee compensatory allowance in accordance with the OM numbers 7+7+7+.
However,
Nothing more. Therefore,
it is important.
order is also passed
Yes.
by the tribunal.
However, my lord,
Yeah.
however, it is made clear that if the government of India issued fresh instructions after 13/11/1987, then the cases of the respondent shall be considered in accordance with the latest instruction. And my lord, thereafter, the first classification came, my lord, only in the year 1/3/1991. And thereafter, all the finance commission, my lord, Mizoram is classified under class C category. Those notifications of the Ministry of Finance has never been challenged, not set aside, my lord. State of Mizoram, my lord, for the first time, my lord, classified only on, my lord, 1/3/1991. And my lord, we had also passed a reasoned order at page 106, my lord, which was put to challenge in the present OA. There also, my lord, categorical stand was taken that Mizoram has never been classified under any of the categories other than class C. I have annexed all the pay commission, my lords, fifth pay commission, sixth pay commission, lord, I have annexed all the documents, my lord. And my lord, our reply at page 106, my lord, maybe, peruse, my lord, that recent order, initially, my lord, they have approached by filing a different OA. That OA was disposed of with a direction to pass a recent order, page 106, my lord. And that recent order was put to challenge in the present OA, my lord. Page 106, my lord. If I may read.
Yes, Mr.
Yes, my lord, 105 may kindly consider, page 105. That was also put to challenge. They are giving a class of central government employees.
In view of the Supreme Court has specifically said that after 1987, the respondent's case would be governed by any instructions issued by the state government.
Yes,
and if
my lord, yes, I am
if
coming,
they classify
I am
as
coming to page 149, 150 of the Ministry of Finance decision.
Yes,
149, 150.
149.
It is a government of India Ministry of Communication and IT Department post.
That is related to Shillong, my lord, not Mizoram.
Please. Dated my lord 149, 1st March 2016.
149 grant of HRA of higher rate B category to central government servants, Aizol.
My lord, the letter is addressed to the Chief Minister Shillong.
Aizol.
Yeah.
That Ministry of Finance decision is page 150. Quoting these Supreme Court observation and directions. 150, second para.
150, yeah.
Second 50.
Agreed as per the Honorable Guwahati High Court so and so.
Yes. It is clear that if government has issued any fresh instruction 87, then the case of the respondent shall be considered according to the latest. Then my lord, Ministry of Finance finding. Consequent obtaining the concurrence of the integrated finance of the department, the matter was referred to the Ministry of Finance Department of Expenditure for decision. Para 5. Ministry of Finance Department of Expenditure has considered the matter and accorded their approval for due decision taken Department of Post not to file any review petition in the matter. Law of Justice advised Department of Post to take administrative decision implementation of the said order. Whether a class of central government employee will get, another class will not get. My lord, this is a Ministry of Finance objection. They have given concurrence and paid them.
But this is in relation to those employees who have approached the court and they have implemented this Supreme Court judgment. As per Supreme Court, we are going to implement that.
Yes.
But what about the observations? How it is made clear that the government of India issues fresh instructions after
My
13/11/87. Then the case of the respondent shall be done in accordance with the latest instructions.
My humble submission is that taking into consideration of that observations and findings of the Supreme Court direction, Ministry of Finance taken a conscious decision.
In relation to those employees only who were involved in this litigation, sir.
They are after 87. All were after 87. Litigation was in the 2020. Why was filed in the year 2020? And my lord, decision, tribunal has given decision in the year 2002. Our High Court has allowed the dismiss the writ petition in the year 2017, 2005. Then my lord, Supreme Court has.
Sir, here, in view of the position enumerated, we have the applicants and also the rate prescribed B class cities of central government employees registered to payable to the applicant at the rate of 15 from 1186 to 3986 and 11086 to 39. And from it at a flat rate prescribed in so and so, so and so. That is in relation to the period prior to 91.
Yes.
My lord, I am reading Ministry of Finance, para 5, Ministry of Finance Department has considered the matter and accorded their approval to view decision to get Department of Post. Do not file a review petition and Law and Justice of the advised department to take a administrative decision implementation of the said order. Honorable Tribunal implementation of the order dated 12/4/2002 passed by the CIT Guwahati bench in 2000. Grant of house rent a B1 class cities rates as admissible from to time agreed to. Since the Department Post has represented India on behalf of the respondent others, approval accorded to the Department of Exchequer and Ministry of Finance is therefore conveyed all the respondent ministries to Department issued instruction in the 2003. That is March after the 1987. This March after the 1987, they are serving and till my lord the departments they are serving in Aizal. They are enjoying this benefit. Can they discriminate one class, union and another?
Let us see, we'll admit this, we'll hear, admit, no need to issue notices, parties, private respondents are represented to their consent. List this writ petition for hearing in the first week of November 2024. In the meantime, effect and operation of the order dated so and so passed by the tribunal shall remain in state. All right. Yes. Next.
Item 32.
At two? Yes, what do you want?
We have not received our rate to our counterpart.
Yeah,
We have not received our rate from the counterpart.
you are for,
And for the state of Arunachal.
state of Arunachal is nothing.
Nothing. Then it's okay.
Receive your instructions by, after lunch, we'll consider. A very short controversy.
Very short, very
Short one. After rising of that, the one review petition is there at 2 and then will.
The review petition, I have relied only on one ground, Lordship. The ground is that, Lordship, the place where the person has been transferred, that is Center of Excellence Thiruvananthapuram, there is no post of Joint Secretary Administrative. His post is Joint Secretary Administrative. The highest post available there is Assistant Secretary. And an Assistant Secretary, H. Annapurni, she is already working there and functioning as Head Center of Excellence. So there is no post of Joint.
They have given you a choice that either join at Trivandrum or Ajmer.
They have given us the choice.
Lordship, that order, Lordship, it is in lieu of Thiruvananthapuram. That has no independent existence.
That order, where is that order? Latest order.
Latest order is at last page, Lordship. Last page. That is after the order of this honorable court.
Yes.
Yes.
This here, after the order of.
Page 513. Page
513.
Page 513.
This is with reference to the judgment so and so. Has been pleased to grant you an opportunity to make a representation in integrity. In view of the above, you are called upon if you wish to make a request to representation competent authority for your posting a joint secretary within 7 days from today. So opt for it. What's the problem in that? If that post is not available in Thiruvananthapuram, go to Ajmer.
Lordship, I had challenged that administrative order, Lordship, and there I have relied upon few decisions.
You can't argue this writ appeal on merits again, or writ petition on merits.
No,
again.
Lordship, if
But
there
see,
is
this is
my
not the scope
submission,
of the review.
yes, my submission is there, Lordship. If there is an error apparent on record, Lordship,
There is no
it cannot be
question of error
corrected by
apparent.
subsequent event, Lordship. These are subsequent events, Lordship.
That's the only ground.
Lordship, that is the main ground, Lordship.
May I make a submission?
This review petition is filed on behalf. If we have
No,
talking
not
about
on
you,
that.
then only.
I'm on something else.
when after the passing of this judgment by this honorable court, we, in view of that last paragraph, gave him a choice that if you opt for Ajmer, he will reply within 7 days. Otherwise, I will presume that you are interested in Tiruvananthapuram.
Yeah,
He has given the choice for Ajmer.
he has already given the
Yes.
choice for Ajmer.
Yes, this is what I'm saying. This is basically a.
Given the choice, then certainly the question regarding that availability of post, then there is no question of
And there
that.
is a post of joint secretary.
But that order for Tiruvananthapuram, that is that is absolutely non-application of mine and arbitrary lordship, because there was no post itself, lordship.
This review petition is filed by the petitioner seeking review of the judgment and order dated 9/9/2024 passed by this court in writ petition number 4124/2024. So, and a concept of the petitioner has submitted that the place Tiruvananthapuram where the petitioner was posted as review petitioner was posted as joint secretary. No post of joint secretary is vacant since some other incumbent is already working as joint secretary there. Full stop. It is contended that this fact has not been taken into consideration by this court while deciding the above writ petition. Stop. It is noticed that pursuant to the direction given by this court in the impugned judgment, the CBSE has granted an opportunity to the petitioner, to the review petitioner to opt for posting as joint secretary / head COE Ajmer and Ajmer by letter dated 11/9/2024, and it is informed that the petitioner has opted for the review petitioner has opted for posting as joint secretary / head COE Ajmer. Full stop. Taking into consideration the above facts and circumstances of the case, and also taking into consideration the fact that by way of this review petition, the review petitioner has attempted to argue the matter on merits, which is not under the, which doesn't come under the scope of the review. Hence, we don't find any force in this review petition. The same is therefore dismissed.
For the very first paragraph, his lordship has dictated that there is the post of joint secretary is held by somebody else is not correct.
His argument.
No. His argument is that there is no post of joint secretary there, and the person who is the head is assistant secretary.
Highest post is assistant secretary.
So,
There is no,
yes,
there is no
that-
post
that
itself.
correction will be made.
That way.
And the post which is being sent to Ajmer has a joint secretary.
क्या लिखा है ये? No post of joint secretary exists. No post of joint secretary exists, and the other incumbent working as
Assistant secretary
assistant secretary
is heading the COE.
is heading the COE Tiruvananthapuram.
And the joint secretary post is there in Ajmer. Got it?
Item 32.
Yes.
May it please your lordship. There are 4-5 dates which will be relevant for adjudication of this matter, my lord. First, your lordship will kindly note 28/3/2024.
The day when you communicated with the authorities.
That's why,
concerned.
yes, where we wanted to merge with NCP, that is page 68 of my writ appeal. Now, lordship has to look into one aspect of the matter. Prior to the date, page 68, please look into page 65. That is 23rd of February 2024. Whereby.
Creation of a new district.
Yes, correct. Because that was a misconception. That's why I have to bring notice to this court. Now, my lord, 68, the lordship has looked into merged, that we do have a merge with NCP with more than 2/3 majority, because after formation of a new separate district.
It is respectfully informed to bring your
Yes.
notice that we undersigned
5 JPMs
including.
into the present JPC out of total 6 JPM members of Kia Pennar district do have a merge with NCP with more than 2/3 majority. Because this notification.
District Jila Parishad.
Yes, my lord, it was bifurcated, separate district. So there was but this was never notified by the government, a separate district. There has to be gazette notification. There was never gazette notification was not there.
This was the notification, but not gazetted.
Correct.
Okay.
So
till the position is this, that no separate district in the name of KV Penyor district has been established.
right, that's the position, man.
As
But
notification is there, but it has not been gazetted.
never did. What? Let's put it. So I thought that will come out of the 6, 5, because that will be a separate district. Just let us put, because that's what is a factual I am saying, my lord. Now, but
The
that's
main reason for your merger with the another political party was creation of a separate district.
Yes.
And that was never created.
never created. That's why I pointed out, my lord, that first notification. Now, my lord, this is 28/3/2024. Now, the next letter is 29, the next day, 29/3/2024. But I have to tell your lordship one thing. There is a statement which has been given to writ petition. On 28/3/2024, your lordship will kindly note that. There is a letter which has been given to the president chair, that is the BJP, that we want to voluntarily giving up the membership, active membership, resigning from the party.
That letter is not.
That letter is not there, but neither that is not a notice which has been given to us. Our notice, so-called notice, is regarding.
In fact, have you ever given any such letter to the president of the political party or not?
I inquired whether there was some letter which was issued. They said that we have issued certain letters.
Issued or
issued?
You have written.
That we have written. We have written.
Yes. Board members have written it to the.
Yes. That's right. Yes. No, my lord.
That is.
That
was not taken effect of by the officer, the authority concerned as well.
No, that has not been taken. Now, if you see at page 70, my lord, page 70.
Yes.
That's a letter where a SOCOS has been issued.
by the
by the
political party.
political party. Now, if your lordship looks into letter, that letter, if you see the first 3 lines, 4 lines, this is with reference to written complaint and representation received by the party office about your alleged misconduct, non-adherence, non-compliance to the direction, notification, circular issued in the interest of the party. Furthermore, allegation that you are indulging into anti-party activity for your self-vested interest. This is why they have issued a so cause. Now, specific averment in the writ petition that we have never received this so cause. Even an argument was advanced to the extent that where is that complaint? There has to be some complaint. Please communicate to us what is that complaint. We want to know it. What is the anti-party activities? That was specific plea which was taken before the learned single judge in the writ petition. Now, this is now 29th. Your lordship has seen at page 70. This is the so cause which was issued. Our specific averment that we have not received.
Yes, sir, this notice, in fact, this page 67.
Page 67, my lord.
This communication is referred to district president, Bharatiya
Yes.
Janata Party.
Yes. Yes.
This you have communicated to him,
This is on 28/3/2024.
28/3/2024.
28/3/2024.
And the next is.
Next is the,
Next is
yes,
to the deputy commissioner, come after secretary of
Yes.
district.
yes, correct, right.
Now, is 29/3/2024
Correct.
letter may speaks about your, this letter 28/3/2024.
My lord, I'm sorry, 28/3.
Yeah,
No,
because you have referred it to the district.
let
president of
us, no, it's correct. Let us say that this, they have taken into consideration of my letter of 28/3/2024.
Fine.
29 is a so cause anti-party activities. Let us say that yes, this is a letter of 28/3/2024, anti-party activity because we are merging with another party. Let us accept this as a misconduct. Now, on 7/4/2024 at page 71 is my expulsion order. Now, I will just read this expulsion order, my lord. Undersigned issued a so cause notice to Srimati so and so, dated 29th of March 2024, to put forth her explanation to the party for breaching of the party constitution by indulging in anti-party activities and non-compliance of the state office direction order party with a direction she may submit her explanation with a period 7 days from the receipt of the said notice. Whereas the undersigned has not received any reply from her till date, which is unjustified, unsatisfactory, and lame excuses on her part, and thereby clearing breaching party discipline, thereby violating article so and so, which ultimately will affect the smooth functioning of party organization in the ensuing general election, assembly election 2024. Therefore, in exercise of power under party discipline of so and so, is hereby expelled from Bharatiya Janata Party for a period of 6 years from the date of this expulsion order. Further, her primary member, active member, and any responsibility assigned or entrusted to her by the party shall cease and stands cancelled. So this is the expulsion order. So there is no reference of the letter which we have given. This is that, yes, this is anti-party, we expelled you for a period of 6 years.
Notice, you have not replied to that, and
Then we expelled you. Now, my lord, this is at page different expulsion order to the all the appellants up to page 74. Now, 75 is an intimation is given by the State Disciplinary Action Committee to the Deputy Commissioner regarding our expulsion. And under the relevant laws, why we should not be disqualified. So this is a letter of 7/4/2024 at page 75, 76. Now, 77, my lord, this is an intimation to the by the state president in charge to the Secretary State Election Commission.
that they expelled these members from.
Yes, right. Now at page 78, it is forwarding letter to the deputy commissioner to all the districts, Tirap district. And at page 79 is the so-called notice which is issued by the deputy commissioner to us on 10/4/2024 for disqualification, my lord. Why we should not be disqualified? My lord, if your lordship kindly look into it, that the so-called on 10/4/2024, that you, whereas while address deputy commissioner, you have intimated, you had intimated for Bharatiya Janata Party, one independent so do hereby merge to NCP with more than 2/3 majority. And whereas state president in charge come chairman so is intimated regarding our expulsion from Bharatiya Janata Party and prayed for disqualification thereof under relevant laws. In view of the facts and circumstances, you have directed to so cause as to why action should not be initiated against you under section 3, read with 4, 5, and 6 of Arunachal Pradesh Local Authority Provisional Defection Act 2003, which is almost parametria 3(1)(a) is voluntary giving up membership, almost is a defection. Yes, 10 schedule. Now, in pursuance to that, my lord, we have written a letter to the deputy commissioner on 16/4/2024. Kindly see at page 80. Furnishing copy of complaint, if any, made against us for disqualification. Somebody we understand have received the above referred so cause. However, we have not been served with the complaint letter whatsoever made by the state president in charge come chairman so and so. Sir, it is especially stated, mere expulsion by any political party does not entail automatic disqualification as member of Jilla Parishad in absence of any specific complaint for disqualification. Therefore, a copy of complaint, if any, made against us may be first provided to us so as to enable adequate reply by the same. Yes, my lord. So this letter, what it indicates, one is an expulsion, which it entails for disqualification. Now, this what we indicated, my lord. The expulsion
is not a
that's
condition for disqualification.
yes, that's what
That
we
is not the condition.
that's not the condition. So that we intimated. Thereafter, on 16/4, before on the same date, we decided to withdraw because there were requests before.
So the factum that you have resigned from the party is established from this withdrawal of resignation letter, means you have resigned from the party once.
That's but
Though that letter or resignation letter is not there,
no,
but
yes, that's
by your own admission.
yes, that's
it is
why
that you
I
have resigned from the
yes,
party.
that I have to bring notice to the court. This is the fact, my lord. Regulation, but because there was a request, that was a general indicator was given by the chief minister before the election. Whoever has come, that they should come back to the party. So that's what we decided. Then withdraw and will come back, join the party. Now, my lord, this is a rejoin at page 82, which we requested. On 23/4/2024, at page 83, the state president in charge has intimated deputy commissioner regarding expulsion and prayer for disqualification.
They informed that, no, we are pressing for this
Yes,
expulsion and all of we are
disqualification.
maintaining that position.
Yes, and at page 85, we have given a reply on 26/4/2024.
Yeah.
On 10/4/2024, specific prayer which has been made at page 87. Kindly say para 5.
Yeah.
That we beg to inform the NC NCP Ajit Pawar has not accepted our merger letter dated 28/3/2024 addressed to your good office. The merger application was submitted a misconception regarding the notification of newly created district so and so. Also, merger was under impression that creation of new district would naturally entail new PRI, Panchayat Raj institution, connotating 2/3 majority as such predicament. Since our merger has not been accepted by NCP and no formal joining was completed, also undersigned has made an ethical decision to uphold the sanctity of the appeal made by the young and dynamic Honorable Chief Minister so and so on 4/4/2024 to all the misguided PRIs to return to the party on or before 17/4/2024 before so and so. Accordingly, undersigned 4 ZPMs already recall withdrawn the merger application so and so submitted to your good office dated 16/4/2024 and also withdrawn from primary membership of BJP. Same has been sent to mail registered post to your good office. Also, we have rejoined on 16/4, the same has been acknowledged to a party office. But due to absence of precedent under other party workers, we could not obtain proper receipt of a rejoining in the party. So this was basically, my lord, the reply which has been, my lord, written to the DC. And thereafter on 14/5/2024, this is an impugn order which has been passed by Deputy Commissioner. Now, if your lordship looks into it, the finding at page 95. My lord, 3, 4, 5, 6, he has narrated and brought all those in this order. Finding, kindly see, my lord, at 95. It is neither denied nor refuted that 4 ZPM member voluntarily tried to merge with NCP under the misconception and bifurcation of district of Lower Subansari into Lower Subansari and Kio-Penyor district. Jila Parishad also stands bifurcated, and that they form more than 2/3 of the elected member of Jila Parishad of Kio-Penyor. It is pertinent to mention here that the Jila Parishad undivided Lower Subansari district has 20 members, out of which 14 members belong to 0I block, so and so. The matter regarding bifurcation of Jila Parishad of undivided Lower Subansari were referred to State Election Commission, who via WT message dated 10/4/2024 replied, Jila Parishad has not yet been constituted in respect of Kio-Penyor district. That subsequent to the merger, attempts made by 4 ZPM members via their letter dated 28/3/2024, BJP expelled the said member via their expulsion order dated 7/4/2024, and the request of 4 ZPM member to rejoin the party resignation has not been considered by the Disciplinary Action Committee, so and so. On question regarding whether disqualification matter can be instituted in order be issued on the while the model code of conduct being in force, the matter was referred to Chief Election Commission, and after obtaining due clarification, this order is being pronounced. So order, if your lordship kindly looks into it, in view of all the material facts as stated above the relevant provision of Arunachal Pradesh Local Authority Provision Defection Act, I am the considered opinion the action of 4 Jila Parishad so and so and so and under so and so act is hereby decided, and that the above mentioned Jila Parishad member stands disqualified. So this order was put to challenge before the learned single judge. Now, if your lordship looks into the judgment of the learned single judge, now this starts from page 26. 26, my lord. I will not trouble by reading the whole judgment. Paragraph 19. Paragraph 19 at page 33.
Yeah.
The petition of volte-face after the merger did not materialize clearly depicts that the plea of withdrawing resignation, expression of interest to rejoin the party or response number 3 is an afterthought. The petitioner have written to the concerned political party that they were withdrawing resignation, and the expression of intention to rejoin the said political party cannot undo the cause of action that has already accrued for the respondent 1 to examine the disqualification after the process initiated by respondent 3 was not recalled. That's a submission which is made by the petitioner. So the judgments.
This is the finding of the court.
No, this is a judgment. This is the judgment of the court is at page 35, para 24. 2 judgments has been quoted, Amar Singh and Viswanathan judgment. Lordship will kindly look at that page 34. 34, my lord. Page 34, para 22.
Yeah.
To test the said submission, it would be appropriate to extract para 11 of case of G. Viswanathan, which is quoted below. para 11, it appears that since the explanation of para 2(1) of the 10th schedule provides the elected member of a house shall be deemed to belong to a political party, if any, by which he was set up as a candidate for election as such member. Such persons who set up as a candidate and elected as a member shall continue to belong to that party. Even if such a member is thrown out or expelled from the party, for the purpose of 10th schedule, he will not cease to be a member of the political party that had set him as a candidate for the election. He will continue to belong to that political party, even is treated as unattached. The further question is, when does a person voluntarily giving up his membership of such political party as provided in para 2(1)(a? The act of voluntary giving up of a membership of a political party may be either express or implied. When a person who has been thrown out or expelled from the party, we set him as a candidate and got elected, joins another new party, it will certainly amount to his voluntary giving up the membership of the political party which has set him up as a candidate for election as such member. Now, 23, in case of Amar Singh Supra, their lordship in Supreme Court of India has merely stated, in case of G. Viswanathan Supra would not apply on these two petition hearing. However, the observation made in para 8 thereof cannot be construed as if the two judges coordinate bench of the Supreme Court of India in Amar Singh has held a judgment of the other two judge coordinate bench India rendered in case of was not a good law. Now, this is the finding, my lord. Kindly see para 24. In the light of the observation made in para 11 of the case of G. Viswanathan, treated with the facts of the case in hand, as narrated herein below, the court is inclined to hold that by letter dated 28 to, it is 28.3, my lord, not 28.2, 28.3, petitioner had informed the respondent number 3 that they had merged with another political party and that they had also clearly expressed that they had voluntarily given up their membership of the original political party which had set them as a candidate for election Jila Parishad of Lower Subansiri. Therefore, for the proceeding, purpose of the proceeding against the petition on the Arunachal Pradesh local authority, petitioner continued to belong to that very party. Hence, the challenge by petitioner to impugn order so and so fails, writ petition is void, found devoid of any merit, and hereby dismissed. My lord, with greatest respect, so far as 24 is concerned, my lord, 24, if I have joined, it is only the purpose that I want to merge with NCP. NCP has never accepted my joining. Never accepted my joining. I have not been inducted as a political party in NCP. So the finding of the learned single judge, my voluntary giving up membership of the party.
How it will make any difference?
I'm
How
showing.
it will make any
How
difference?
I'll
If
give
a- If a member of a political party voluntarily resigns or voluntarily
giving up his membership.
even though without joining any other political party, voluntarily he can give it. Give it up.
No, then now that I will just
What is
give
the condition?
well,
that
I'll
the
give a
voluntarily given up for merger with other parties.
no, that is the case in I'll read that case. Viswanathan was that case. That two things.
That was Vishwanathan was the case where the court come to the conclusion that if a person is expelled from the party, then he would remain member of that party despite that expulsion. And the moment he joins other party, section 3 will come into force.
Right. Now the
That is
question,
what
can I give an answer to
and
you?
against that, a doubt was raised. The doubt was another bench of the court has raises a doubt that this is not a good law and refer to the larger.
Now the question two, I'll just give it to reply, quick reply, or Lordship has put on first. First is that, my lord, it is a fact that yes, we intend to join and merge with NCP, but we did not. My lord, your Lordship will carefully just listen. We did not join the new party. We did not join. My lord, I am willing to go to a party, but that party has not accepted. So, my lord, my respectful submission,
So section 3(1)
yes,
is not dependent on any of the fact that whether you have joined any party or not.
no, that's
It
the fun.
speaks only about voluntarily given up the member.
Correct. My let us say voluntary giving up the membership, active membership from BJP. That's our case, right? Now, my intent is to merge with NCP.
For X, Y, Z reason.
Yes, my intent is to merge NCP. Now,
Intention was there, yes.
no, but I did not join. No, that's the case. My lord will kindly see. Which one was that?
Disqualification has to be on the PIL. Any judgment is not dismissal judgment. Dismissal judgment. This was a. Yes, my lord will kindly look this 10 schedule, my lord. First, your lordship will take into 10 schedule constitution, my lord. Fine. 2(1)(a). Kindly see 2(1)(a) of 10 schedule.
Yes.
Disqualification on ground of defection. Lordship got it?
Yeah.
Subject to the provision of paragraph 4 and 5, a member of house belonging to any political party shall be disqualified for being a member of the house. A, if he has voluntarily given up his membership of such political party. Now we are on A.
Only.
If he has A, voluntarily giving up his membership. This particular went on debate with G. Biswanathan case. I'll show it, my lord. Kindly look at 1996 to SCC. That's the judgment which I have given to your lordship. Yeah. Para 500. Now see para 5, my lord. Lordship got it, para 5. We heard Mr. Santi Bhushan senior counsel for the appellants, and Soli Sarabji, senior counsel for the respondent. The main thrust of the submission made by the appellant counsel was that para 2A of 10 schedule of the Constitution comes into play only to disqualify a member who voluntarily giving up his membership of the political party that has set him as a candidate and not when he is expelled from the party and declared unattached. That is not belonging to any political party. Now, further, my lord, this is what expulsion and my lord disqualification are two different things. I may be, yes, I may be expelled
This
for.
expulsion of business doesn't find mention in section 2.
Right,
of
right.
The 10 schedule.
Correct, correct.
Doesn't find any mention.
Absolutely, my lord. Now the question hasn't propped up voluntary giving up the membership of the
That's the
party.
only thing.
What is the effect of that? Suppose I voluntarily give up.
First of all, what is the voluntarily, what connotes the
Yes,
voluntary
correct.
given of the membership?
Yes,
What connotes that?
yes. Whether A will be my intent to merge with a party, namely NCP, one, whether that's amount for voluntary giving a membership of that party. B, whether I have joined that party, NCP.
That is inconsequential.
No, no.
We, prima facie, we are of the view that once a member of a particular party voluntarily give up the membership, either by resignation or his conduct, that's enough.
No, that's not.
That's enough.
Yeah.
Whether he has joined for what purpose he is resigning or giving up the membership, whatever it may be, that is inconsequential. We can't take into consideration. We only have to see whether he has given up his membership voluntarily or not. That's the only thing.
But that I will respectfully, my lord, I will just read this, my lord, further down below. What was the debate that was made in that particular case? How it has been dealt? The question that has been put forward by your lordships, whether your lordship says enough, your intention to merge is enough. That's
Not intention to merge. Merge is altogether different thing.
Yes.
Your intention to voluntarily given up the membership.
No.
That's enough.
no, the voluntary giving of a membership has to be read with this thing. Has to be read. No, my lord, with greatest respect, I will submit before your lordship. Here is a case where voluntary giving up a membership from a party. From a party.
From the party.
Subsequent,
From
from
which
a
you were
party.
elected.
Subsequently, I join another party. Or I wanted to join another party. Whether, my lord, that's what your lordship will read further, my lord.
Yeah, read.
Yes. How does the voluntary come into picture? How does the voluntary come into picture? Member himself of his own function is one related party. When the member is function, we have find only when the member himself of his own violation his membership of that party. Any member thrown at a
Yes.
Now, my lord will kindly see paragraph 5.
Yeah.
Paragraph 5, we stop there. Unattached, that is not belong to political party. We stop that. My lord, further, your lordship, para 2A will apply only when a member himself of his own volition gives up his membership of the party. Any member thrown out or expelled from the party that had set him as a candidate will not fall within the mischief of para 2A. By expulsion, the member thrown out will cease to be a member of the party that set him as a candidate, and even if he joins another party thereafter, will not be a case of a voluntary giving up his membership of the political party that has set him as a candidate for the election. On the other hand, counsel for the respondent Soli Sarabji submitted 10th schedule of the Constitution should be interpreted strictly and keeping in view the mischief sought to be prevented by enacting the law. It is evident that though expulsion by political party that has set up a person as a candidate by itself may not attract 2(1)(a), further act of his joining another party amounts to voluntarily giving up the membership of the political party that has set him as a candidate. Learned counsel submitted deeming provision contained in an expedition should be given full effect, and in light of the finding that the application has joined another political party, the High Court was justified in confirming the conclusion of the Speaker that the appellant has voluntarily given up membership of the political party that has set them as a candidate and has thereby incurred the disqualification of being members of the Assembly under Article 191(2). So here is a case, my lord, your lordship, has joined another political party. Yes, that amount of voluntary giving up the membership. Yes, I have been
expulsion.
Yes, I have been expelled. Expulsion has been. I was expelled for what purpose, my lord?
Sir, you were not expelled.
I was expelled first.
Later on.
No. I mean,
Later on, 7/4,
no.
you were expelled.
No. I'm sorry to say.
Sir, on 28/3/2020,
I have.
when you moved an application.
Yes.
Or a request.
Yes.
We are going to merge, or we have merged with so and so party.
Right.
And we are informing you.
Yes.
At that time, you were not expelled.
No, I was expelled on 7/4/2024. Now expulsion, if your lordship will look into the order of expulsion.
But what we try to just place before you, that prima facie we are of the view that the moment you have written this letter on 28/3/2024 to the concerned authority, this section 3 of this, whatever act or the name.
3(1)(a) of the Arunachal Pradesh, yes.
Comes into play.
Yes.
That is what a prima facie comes into play. And whatever this voluntary given up of membership complete on 28/3/2024. What was your intention? What was your purpose? Either merger with another party or to whatever the reason, that is inconsequential. Only the officer has to, or the authority has to look into, take into consideration whether section 3(1)(a) comes into force or not. This is what.
No, your lordship is looking to expect to the extent that on 28/3/2024, your chapter is closed.
Yes.
That's what your lordship is saying.
Itself.
Chapter is closed.
28/3/2024, the moment you.
So once we give a letter that we are merging with another party, that is enough. Voluntarily giving a membership.
That is voluntarily given up this membership.
Now with great respect, my lord. That's your lordship prima facie view. That's your lordship prima facie view.
Yeah.
Now my submission before your lordship will then I understand from Vishwanathan judgment, my lord. This is my understanding of the judgment.
What we again, let us clarify.
Yes.
What we are understanding this Vishwanathan judgment.
Yes.
Vishwanathan judgment, one party tried to suggest that if a member is expelled from the party.
Yes.
And after his expulsion, if he joins any another party,
Yes,
then section 3(1) will not come into operation. Section
Right.
2(1) of the RP Act, where this 10th schedule will not come into
Right.
operation. The court holds otherwise.
yes,
Okay, even though if you are expelled from the party, until you have not joined any other party, you will remain as a member of this party as per explanation 2A or whatever the explanation
Yes.
in 10th schedule. And moment you join other party, the section 3.1 or the section 3(1) will come into play.
yes,
That is what
right.
this view was doubted by another bench of the Supreme Court and says, "Okay, no, why when a person is already expelled from a party, why he can't join any other party?" And they have raised a doubt and the matter is pending before the larger bench. That is a different situation what we feel. Here the situation is when this section 3(1) come into operation. And our prima facie view is that once you have given up membership voluntarily, that comes into the section 3(1) come into operation, and the subsequent events, withdrawal, rejoining, anything else, that is inconsequential.
But my submission, well, I know, I understand your lordship, but my understanding of this judgment.
Yeah.
Because Amar Singh judgment, but that has been referred to a larger bench. I think that is over because now on 8th of August 2024, it was placed before the three judges, Amar Singh judgment.
Again,
And he's saying that in personam, judgment in personam is no more, he has died. So
so
we'll not look into that aspect of
again,
it.
in
Yes.
2016, they have done so.
Yes, see, he got it. And this one, I have a copy. Give me a copy.
So unfortunately, this G. Vishwanathan still holds the field.
Remains.
Whatever it may be,
Yes.
may or
kindly-
may not be correct view. That has already been,
Yes, see, but please, my lord, this, but the issue which I have gone to the judgment, if you see at para 11
yeah,
of Biswanath judgment,
yeah.
first your lordship will look into that Amar Singh that goes again. See Amar Singh judgment, my lord. That the honor, that. Put aside.
Here the 2016.
2016, kindly see.
Yeah.
The writ period disposed in terms of the sign order. Now thereafter,
They said they will not interfere because.
they will, yes,
They refuse to
Yes.
answer.
yes. Now,
16.
2016. Now thereafter, see at this judgment of 2008, August 2024. 8 August 2024.
August 2024, I think so.
No.
We have not supplied that.
Yes.
It is there.
Yes. Ma kindly see the,
Petitioner filed a seeking.
yes, expelled from political order, petitioner expelled from so and so. Learned petitioner that during the pendency, the petitioner has after passed away. Relief sought a personal, the petitioner in the sense that he has petitioning on disqualification of being expelled, which elected him, learned counsel petitioner seems to be right, has become infructuous in so and so, penance shall also stand dismissed. So see, Biswanath revives.
So the same order of 2016 was reproduced.
So now my lord will kindly see 11.
So we are back to zero.
Yes, yeah, that's right. That's right. My lord say, C11, my lord.
Yeah.
11. Did appear that since the explanation of para 2(1) of the 10th schedule provide an elected member of the house shall be deemed to belong to a political party, if any, by which he was set up as a candidate for election as such member, such person to set up as a candidate and elected as a member shall continue to belong to that party. Even if such a member is thrown out or expelled from the party for the purpose of 10th schedule he will not cease to a member of political party that has set him as a candidate for election. He will continue to belong to that political party if he is treated as unattached. The further question is, when does a person voluntarily given up his membership of such political party as provided in para 2(1)(a)? The act of voluntarily giving up the membership of the political party may be either express or implied. When a person who has been thrown out or expelled from the party, we set him up as a candidate and got elected joins another new party, it will certainly amount to his voluntary giving up his membership of the political party, which have set him as a candidate for election as such member. So what I am saying in this paragraph, my lord, what I've understood from this paragraph, that voluntary giving up my membership on 28/3/2024, that will remain, they cannot count that voluntary giving up. Because kindly see, my lord, the further question is that when does a person voluntarily giving up his membership of such political party as provided in para 21A, the act of voluntary giving up the membership of the political party may be either express or implied. When a person who has been thrown out or expelled from the party
Yeah.
My lord will kindly see at page 79 of my appeal. 79. So-called notice by the DC, my lord. For disqualification.
79.
79.
Show cause notice by whom?
By Deputy Commissioner.
Yes.
Why should disqualify? Kindly see the first 3 lines. Whereas white letter dated, you also got it?
Yeah.
Address to so and so Bharatiya Janata Party 1 independent district. Do you have a merge to NCP with more than 2/3 majority? So here is not a question where they said you have voluntarily given up your membership, that's why we are disqualified. That is not the case. How can they disqualify under 3(1)? This is not a case of so-called notice that you have voluntarily giving up your membership, so we want to disqualify you. Where is the so-called? So-called is only merging. For that purpose, they have expelled me for merging. Merging with another party, that's what they have expelled me. Disqualification, my lord, disqualify voluntary giving up membership. So we were disqualified, we were asked to give a show cause. Why you have done it? Where is that? That is not there. They know very well. That is not a ground, my lord, show cause notice being issued to me. Kindly see the show cause notice, my lord, issued to me.
Yes.
It's a merger. Do you have a merge? For that purpose, how can I be disqualified? I can be disqualified voluntary giving up. That is not your show cause. That's the whole case, my lord. For that purpose, you have expelled me from the party.
Yes.
I could very well understood your show cause would be on based on your that voluntary you have given up your membership from the party. So why you should not be disqualified? That's not the ground. Yes. My lord will kindly see at page 83, which is intimated by State President in charge, BJP, to the Deputy Commissioner on 23/4/2020. To initiate disqualification, kindly see my last paragraph or at page 83, my lord. It is to apprise, your lordship got it?
Yes.
At page 83, my lord.
Yes.
It is to apprise your kind of a Bharatiya Janata Party strongly prays for disqualification of above member, claim for withdrawal or merger to NCP of the expelled member, nothing but calculate afterthought claims in order to escape from the consequent expulsion and disqualification. All the members may be disqualified. That cannot be a ground. If you are taking a ground on the 3(1)(a), voluntary given, the show cause should have been on that.
No, they are referred to it in the show cause notice itself,
Yes,
in the third para.
yes. Page 79. Yes. My lord, 79.
Yeah.
Yes. And prayed regarding your expulsion from Bharatiya Janata Party and
In
prayed
view
for
of the above facts and circumstances.
yes.
You are hereby directed to show cause as why action should not be initiated and you under section 3.
Yes, well, but your, my lord will kindly see the first paragraph. That's your whole foundation. My lord, whole
Where by
foundation.
lettered address,
My lord,
intimated 4 members as joint party with more than 2/3 majority.
My lord will kindly, that's a merger. That's why I'm saying, my lord, you may quote 3, you may quote 4, you may quote 5. You have quoted 3, but quoted 3 has to be justified with your foundation of your so-called notice.
They have taken note of your letter and thereafter gave the contents of your letter. But
My lord, 28(3) is a merger. It is not that voluntary giving up membership.
merger without voluntarily given up membership of a particular party, merger with the NCP.
No, it is not even a ground which has been mentioned. My lord, my merging with a party, my merging which I have not merged. My lord, that is why if your lordship looks into the entire judgment
Suppose a member of a particular party and he express his wishes or whatever it may be, or he made a statement that I'm going to join so and so party. His intention is very clear. I am going to join so and so party. Later on, he joins or not joins. Whether that his desire expressed, his
voluntary giving up, voluntary giving up his membership. That's my lord, respectful submission before your lordship.
Because in Ravi Naik's case, the Honorable Supreme Court has dealt with the issue.
Yes.
Para number 11.
Yes.
I think so. You have the judgment of Ravi Naik case.
Yes, yes.
That's 1994 supplementary to SCC. Para number 11.
Yes, it's there in Vishwanath judgment they have quoted my lord.
The appeal has been filed by, they have been disqualified from the member of assembly, so and so on the ground defection under 2A and 2AB of the 10th schedule. From the judgment of the appears that the disqualification on the ground of para 2B was not pressed on behalf of the contesting respondent. The disqualification was sought to be ground of para 2 only. The said paragraph provides for disqualification of a member belonging to a party if he has given voluntary if he has given, voluntarily given up the membership of party. The words voluntarily given up his membership are not synonymous with resignation and has a wider connotation. A person may voluntarily give up his membership of a political party even though he has not tendered his resignation from the membership of that party. Even in the absence of formal resignation from the membership, an inference can be drawn from the conduct of a member that he has voluntarily given up his membership of a party to which he belongs.
Yes.
Now your conduct, writing a letter to the authority concerned, can we have merged with so and so party? That doesn't amount to voluntarily giving up this membership.
My lord,
And subsequently, coupled with the fact that you have resigned also and then withdrawn that
but whether,
resignation.
but by this, what is the so cause notice you have issued?
Show cause notice, they have said, this merger, you have given this merger.
But if you see, my lord, if you see the para page 70, where my expulsion was at page 71. 71.
Sir, even in this Ravi Naik
No.
case, in CA number 3309 of 1993, two members of the legislative council belonging to a particular party appeared before the governor along with a different group, and they said, yes, we want to support him as become a CM. The Honorable Supreme Court has said that this conduct itself is sufficient to show that you have voluntarily given up your membership of that party. This was the case.
But
They have simply went along with the one of the leader of a party, accompanied, and they paraded before the governor and said, yes, we are supporting him. That was enough, sir.
But my lord, on 16/4/2024, I have intimated they want to withdraw it.
It's a very question of withdrawal.
Thereafter, my disqualification came on 14/5. But by 71, my lord, with great respect, the expulsion order, which has been passed by them on.
Sir, what we feel, if we allow such type of practice, then it will defeat the purpose of this defection law itself.
But there are instances also, my lord, don't want to say much about the conduct of the party, BJP. That's
absolutely
that is also dangerous. My lord will kindly see that's what was argued in Amar Singh case, my lord.
Yeah.
We have to look into all other aspects of the matter.
In fact, expulsion, suppose certainly if this order of your disqualification order was based only on this fact that you have expelled from party, certainly a case for inference is made out because any party can expel any member at his whims.
Yes, right.
And now he will be treated as a that case is treated as a defection. That is not permissible at all.
Now, my lord, when 71, you have expelled me, and you said that expulsion is only because anti-party activities and a complaint.
That is immaterial. Even
No,
though they have expelled it or they have not expelled it, once you have voluntarily given up this membership, that section 2A comes into play.
But they have not accepted, my lord. That's the whole case.
Sir, that's why only
they have not accepted.
That's why only I read this para of the Ravi Naik case. Even in the absence of formal resignation from the membership, an inference can be drawn that a conduct of the member that he has voluntarily given up his membership altogether to which he belongs. There is no even question of giving any resignation even or conduct se bhi party ka, if a member of a party is member, this conduct is like this, it can be inferred that he has given up the membership of that party.
But my lord, when you issue a so-called notice to me on 29th of March 2024, some anti-party activities plus a complaint has been lodged. Am I not entitled? That was a specific ground we have taken before the learned single judge. My lord, that yes, 28(3). Am I not entitled to serve them to serve a copy? What is a complaint that is against me?
That is, even though he has mentioned that, though we feel that once you have given this letter to that party, authority, that we are going to merge with so and so party. And actually, no such district was even constituted. The authority should have taken this, could have taken this suo motu action, that you
but
have
the-
voluntarily given up this.
But
membership.
authority, while deciding my matter, even in the SOCOS, even in the expulsion order, even a deputy commissioner while deciding it, it is only a case of merger. It is not, my lord, my respectful submission is not for voluntary giving up membership from the party. That's what my case, my lord. Not voluntary giving up membership of the party. So disqualification only can happen only under only 10 to A, 1A. No other ground. They have done, they have expelled me. Okay, I'll remain unattached with the party. Expelled for 6 years. Thereafter, you have written to Deputy Commissioner, we expelled, so you disqualify. So I'm before this honorable court saying, how can they disqualify only just on the ground expulsion? We expel because of merger of a party, so we are giving notice to you to please disqualify him. So never a notice, my lord, under this under the provision for voluntary giving up membership of the party. So paragraph 16 of my lord, what did it express in one paragraph? Your lordship will kindly look into it. Even then, Amar Singh case, one paragraph, my lord. Para 16, my lord.
Just a minute.
Of 2011.
Just a minute.
Yes.
Yes, Amar Singh judgment.
Yes, para 16 kindly we see. Para 16, no?
Yeah.
We are also convinced, para 16, in the background of the legislative history of the introduction of 10 schedule in the constitution in which it was initially intended to include expelled members within the ambit of provision relating to disqualification. The same was dropped after the debate in parliament in which the dangerous effect of the inclusion of such a subclause were pointed out by many of the members in the house. If it was the intention of the legislature not to include expelled members of a political party within the category of person who could be clubbed with the category of person who voluntarily resigned from membership of the parties, the same could not have been imported in the 10th schedule by virtue of judicial pronouncement in the said case. In fact, what was sought to be excluded by legislature has now been introduced into the 10th schedule by virtue of the said decision.
Now,
Now
to
17.
to the following question.
Yes, we are now convinced, we are following 17, that decision of recent case merits another look so far as a member of house who are expelled from the parties on whose banner they have been elected to the house are concerned, as they would be left completely vulnerable to the whims and fancy of leaders of the party. We therefore issue rule in two writ petition, request the Honorable Chief Justice of India to refer larger bench of the on the following question, whether the status in either House of Parliament or the state legislature member is expelled from the party, we set him are as a candidate for election.
So you don't belong to this class?
Yes.
You
No.
don't belong to this
No.
class? Yes.
Will the provision of 10 schedule to the constitution apply to such member?
Not
Yes. Was the view taken case with regard to status of member in either house of who had not voluntarily resigned from the party but had expelled therefrom in harmony with the provision of the 10th schedule?
That is also not.
Yes, in view of the fact so and so, whether now whether a member of either house is expelled by party which has set him as a candidate, which he either joins another political party or forms of, can be said to have voluntarily given up his membership of a party in view of the legal fiction created by explanation A 2 para 2(1) of the 10th schedule.
That is also not.
Yes. Said that he had voluntarily given up.
Doesn't belong to the class of persons who have voluntarily given up the member.
What I
It is
was,
in relation to only those persons who have been expelled from the party.
my lord, my submission before your lordship is to conclude, my lord. A, my lord, I have been expelled from the party for some anti-party activities. Even I wrote a letter for margin with NCP.
But
I
no
never,
merger- no merger took place.
yes, I have never joined the party. I have never joined the party. And the foundation where a SOCOS has been issued is really a merger as SOCOS has been issued. And for merging a party, I can be expelled. I have been expelled. That cannot amount to disqualification from the party. That's my
Because no merger took.
no merger
no
took
merger.
place. That's my case, man. I am deeply obliged, my lord.
Yes.
Yes. Before I go to the fact, I'll go to the 4 documents and 4 dates, just to say that there has been a incident of voluntarily giving up his membership of the party on whose ticket he was elected. Before that, I'll just clarify one thing. My learned friend has been repeatedly arguing that in G. Vishwanath, there was a requirement of holding that they have joined the new party. It is because, my lord, that was a completely different case. There, my lord, from the side of the disqualified members, no action was there. It is the party who expelled them. So something was necessary to hold that he has actually given up his membership here. Here is a case by their conduct. My lord, they have resigned from the primary membership, number 1. Then they have joined they have merged. They are arguing that we have intended. No, their document will show they have merged with that party. This is second. Thirdly, my lord, the fact that their merger was not accepted is absolutely irrelevant here. We are not concerned with what happens after he leaves our house. He has left my house. He has wanted to join some party, was not allowed. That is absolutely irrelevant. What is relevant is whether by your conduct, as the Supreme Court has said in all the cases, he has voluntarily given up the party on whose ticket he was elected. Now, G. Vishwanath is the case where from the side of the members, there was no action. It is the expulsion from the party. So from his side, there is no action. So that is why there was a necessity of holding that whether his joining was complete or not. That is why Lordship will find in G. Vishwanathan, my lord, in the penultimate paragraph, it has been held. Just above paragraph 15, the subparagraph above 15, my lord. It was a case of expulsion from his side, from their side, there was no resignation, nothing. It was a case of joining the party after expulsion. So expulsion is an action by the party itself, not from his side. Lordship, may kindly turn to the paragraph just above paragraph 15 of G. Vishwanathan. If your lordships have got, my lord.
Yes.
Last page. If he of his own volition joins another political party as the appellants did in the present case, he must be taken to have acquired the membership of another political party by abandoning the political party to which he belonged, or must be deemed to have belonged under the explanation to para 2(1) of the 10th schedule. Of course, courts would insist on evidence, etc. So here this was necessary because factually, from their side, there was nothing, no action, nothing, no incident by which a finding can be arrived at that he has voluntarily given up his membership of the party. Now, your lordship has seen, my lord, para 11. I'm just reading para 11 once again. That was the case, my lord. Initially, the speaker passed an order of that they were unattached. Subsequently, there was another representation that no, kindly disqualify them. Thereafter, the governor, my lord, speaker disqualified. Now, para 11, I'm just reading for a moment, my lord. It appears that since the explanation to para 2(1) of the 10th schedule provides that an elected member of a house shall be deemed to belong to the political party, if any, by which he was set up as a candidate for election as such member, such person so set up as a candidate and elected as a member shall continue to belong to that party. Even if such a member is thrown out or expelled from the party for the purposes of the 10th schedule, he will not cease to be a member of that political party that had set him up as a candidate for the election. He will continue to belong to that political party, even if he is treated as unattached. The further question is, when does a person voluntarily give up his membership of such political party as provided in para 2(1)(a? The act of voluntarily giving up the membership of the political party may be either express or implied. when a person who has been thrown out or expelled from the party, who is set him up as a candidate and got elected, joins another party, it will certainly amount to his voluntarily giving up of membership of the political party, which had set him up as a candidate for elected or for election as such member. So my humble submission, my lord, the G. Viswanathan, there is a requirement of holding that he has joined the new political party, which my learned friends are arguing, we have not joined. That was required in that case to record a finding because the previous act was only an act on the part of the party. From his side, there was nothing. Now I am coming to the present case, my lordship. I will suggest four documents and very briefly conclude my submissions, my lord. Lordship may straightway turn to the page 85, where he have filed the, I'll come from the backside, my lord, from where he has filed his reply and their intention, as your lordship has said, my Supreme Court has said, by their conduct. What was their conduct? Page 85, madam. If your lordship goes to page 85, your lordship will find what is their conduct, what was their intention. Yes. My lord, page 85, lordship will kindly see the second paragraph. I will not do the entire one, my lord. Second paragraph at page 85, bottom. That we beg to state that there are 5 elected Jila Parishad members from BJP in Keni Paniyar district, and out of 5 ZPMs, 4 elected ZPMs from Deed, Pistana, Parampatu, etc. constituency constituted 2/3 majority. On coming into force of the act in respect of KE Paniyar district, we, the elected 4 BJP ZPMs, has decided to merge with the NCP, Ajit Pawar, in protest of the present leadership of the constituency, and accordingly, we undersigned has submitted merger application to your good office by later date so with outside support from one independent ZPM in a bona fide belief that power and function of Jila Parishad constituency has been separated for KE Paniyar and Lower Subansiri district. Now, the third line from the bottom, my lord. However, owing to non-clarity on separation of power, Jila Parishad constituency in respect of the Lower Subansiri district and KE Paniyar district, as a resultant, we had already withdrawn the merger application date so submitted to your good office. Now, the next page, just 2-3 lines. That we beg to inform you that NCP Ajit Pawar has not accepted our merger letter dated so addressed to your good office. The merger application was submitted under misconception regarding the notification of newly created district, KE Paniyar. Also, the merger was under the impression that creation of new district would naturally entail new PRI, that is public Panchayat Raj institution, connoting 2/3 majority. In such predicament, since our merger has not been accepted by the NCP, and no formal joining was completed. Also, undersigned has made an ethical decision to uphold, etc. So, my lord, here is a case. I am just indicating what was the district was created. My lord, my learned friend submitted the district was not created. District was created, but in terms,
was not
my lord, in terms of section 85 of the Panchayat Raj Act 1997, another gazette notification was necessary to constitute the Jila Parishad.
Separate Jila.
Now, somehow, my lord, they thought they are in majority because these persons would fall, their constituency will fall into the new ZPM to be created, yet to be created. And they, out of 6 will go there, out of 6, 5 have decided to immediately merge. So there was some hasty decision, and therefore they have earned a disqualification. Now they have made intention very clear by this letter that even now we are saying, actually we wanted to go. We wanted to go. It is only because there was some confusion about creation of new district. We thought that the creation of new district will automatically create a ZPM. So that shows that they are making their intentions very clear that we wanted to go with NCP because of our protest against the leadership.
Already merged.
Merged. Now, Lordship, just 2 more documents I'll show and then conclude my lesson. Lordship will kindly turn to page 81. Well, page 81 is the letter which just seals everything. It says, we the undersigned have resigned on 28th March 2024. Number 1, from the primary membership of BJPs in protest. Now we have decided to withdraw our resignation and will remain in the party. We have been informed that Young and People's Honorable CM have appealed to PRI leaders to come back to the party in recently. Therefore, sir, we, the undersigned, hereby rescind, recall, cancel the resignation letter, etc. So, what you are confirming is you have resigned from the membership, number 1. Now you are trying to withdraw that and come back to the party. My lord, whether you'll be allowed to come back to the party or not is a decision of the party. You cannot say that since I have written a letter to come back, so I should be treated to be a person or member belonging to this political party. Now you are saying that I have resigned from the primary membership. You are saying that I have decided to withdraw my resignation. That means you are confirming that you resigned, and now you want to withdraw that. These are sufficient materials to hold that they have voluntarily given up their membership. And then, my lord, the last letter is the letter by which they have actually merged. They are saying that we have decided to merge. No, it was a merger. Page 69, my lord. Lordship, kindly. Party. Page 93. Yes, my lord. Just two more pages, my lord. Page 68, my lord. Is the first letter of 28 March. I'll not take much time, man.
Yes.
Page 68. It is to respectfully inform and bring to your notice that we, the undersigned, ZPM out of 6 ZPMs of K Penur District Jila Parishad, do hereby merge with NCP Ajit Pawar with more than 2/3 majority. So intentions are more than clear, man.
ये बहुत बार तो लिखा है सिंपली से very letter difference do hereby not I should
Just one more text, my lord. Just one.
yeah.
Page 92. I'll not take to any other text, my lord. Page 92. This is the impugned order passed by the deputy commissioner.
Yes.
There, my lord, while taking note of the argument made on behalf of the present respondent before lordship, my lord, it has been mentioned that to the above contents, sir, advocate so-and-so appearing for the state president in charge of chairman, state disciplinary committee, BJP, Arunachal Pradesh, submitted that 4 JP members had made their intention to break the party loud and clear by submitting the merger application so to the office of the undersigned and produced, and this is important, the copy of the newspaper extracts wherein the 4 JP members joining or extending their support to the candidate of NCP Ajit Pawar Yechuli Assembly constituency were available in the public domain. So just like the case of my lord that lordship has been referring to, the Rajendra Singh, where the person accompanied the other members to the office or residence of the governor to make so-and-so as a chief minister, para 48 and 49. I'll just conclude, my lord. I'm just relying on, my lord, the G. Vishwanathan, para 11 and 14. Then Ravi S. Nayak, para 11. The lordship has said, my lord, I'll not read again, my lord. And so far as this 2007 4 SCC, page 270, Rajendra Singh, my lord, which your lordship was just now referring to, my lord, para 48 and 49.
270.
My lord. Two 2007 4 SCC 270 Rajendra Singh Rana versus Swami Prasad Moria.
This is a constitutional bench.
My lord. Para 48 and 49. Page, lordship is straightway turn to page 303, my lord.
Yes.
Para 48 is like the act of giving a letter.
Yes.
The act of giving a letter requesting the governor to call upon the leader of the other side to form a government itself would amount to an act of voluntarily giving up the membership of the party on whose ticket the said members had got elected. Then we can skip and Ravi S. Nayak has been quoted. Then next paragraph, para 49. Clearly, from the conduct of the meeting, the governor accompanied by the general secretary of the Samajwadi Party, the party in whose opposition, and the submission of letters requesting the governor to invite the leader of that opposition party to form a government as against the advice of the chief minister belonging to their original party to dissolve the assembly, and irresistible inference arises that the 13 members have clearly given up their membership of the PSP. No further evidence of inquiry is needed to find that their action comes within para 21A of the 10th schedule.
Yes.
That's all, man. In my humble submission, there is no illegality in the order passed by the deputy commissioner as well as the honorable single judge.
No, only just 2 minutes reply, my lord. Just a 2 reply. My lord, the 2 reply from my learned friend. A, my lord, the disqualification of the present appellants is not on the ground of neither regulation, A, or neither is a ground for voluntary giving up his membership, A. Now, number B, while issuing a so-called notice to us, saying that indulging anti-party activities on a basis of a complaint, we have never received that complaint. 2. Number 3, while deciding and passing an order by a deputy commissioner and member secretary, there is no finding to the effect that about the conduct part. There is no finding. There has to be finding on the part of deputy commissioner for disqualifying us.
So,
There is no finding as such.
just see.
The finding is only on the ground of merger.
No.
Kindly see the order of the deputy commissioner.
Sir,
Which
it
has
is neither denied.
Yes,
The findings, na?
I'm sorry.
Not refuted.
Yes,
That 4 Jilla Parishad member voluntarily tried to merge with the BJP
yes,
under the misconception that so and so
Yes.
elected members. It is
Yes.
pertinent to mention here that the Jilla Parishad matter regarding this, he is considered, sir.
No,
That
which one?
this is your voluntary action of giving up the party because you merged,
But
tried to
that,
merge. In fact, you have merged with the party. That's another thing. The subsequent of the merger attempts so and so and so, BJP expelled the said members. That the request to rejoin the party by withdrawing resignation has not been considered term. In view of the all material facts as stated above, the relevant provisions of so and so and so and so.
my lord, there is no finding, my lord. This is very important. That my merger to join a party and my intent and expression to join, merge with another party who has not accepted my merger, my lord. Who has not accepted my merger. There may be intent, my express to merge, but it was never joined the party. Neither it was a ground of disqualification, neither a ground, disqualification was not a ground of resignation, neither it was a ground that voluntarily giving our membership under the 3(1)(a) of the Act, to the Arunachal Pradesh Act.
Sir, please give us this copy of the whole act.
Yeah, I'll give it, my lord. Edison, already I have the, this is paisa. No, this one. We have given the site of is, no, this one.
Sir, this is the whole act.
Yeah, yes, we have given, that's, yes. Yeah, 4 pages.
Only 4 pages.
Only the job बोलते हैं। तुम्हें क्या नहीं हुआ? ठीक है।
कोई नहीं करता मुझे
3(1)(a), 4(5).
That is the end of the.
3(1), 4, 5, 6. It will. Yes, it is enough. Let's see. Let's see. What is that? Act for that. 2003 Act. He'll just reconfirm from my learned friend.
Because in the last page again 178 page after 180 again 178 page आ रहा है.
How many page? Only 1 page, maybe 5 page, maybe.
I have the complete act along with the amendment.
No, we have also given that amendment. Amendment is there.
I have done some highlighting for myself. Complete man.
This
I think
one and the same.
Same? I was a bit afraid that it is not same.
Huh?
I was just holding them that it is the same or not.
No, same. So font change. Otherwise.
Deeply obliged.
Actually, my lord, he is also hurried. He's looking to watch because we both have to go to Arunachal Pradesh.
You have to go somewhere.
Arunachal Pradesh.
Now,
There is a matter tomorrow.
now.
So he is, while arguing,
Order is a
while arguing the matter, he was saying, Dada, enough.
हो गया है.
हो गया.
Sorry.
अभी आज का फीस पूरा हुआ कल का लेना है.
I'm deeply
Deeply
obliged.
obliged.
Deeply obliged.
Thank you.
Deeply obliged.
Order is a
Yes. पर आपको बोल रहा है, तो खाता है.
Iman Hari. Very
My lord, in a very lighter vein,
Yeah.
there was a senior counsel here. I think Honorable Justice Mr. James Chaudhary. He is one of the topmost criminal lawyer.
okay.
Topmost. He was the best criminal lawyer here. So he happens to my own uncle, Mr. James Chaudhary. Now, whenever the matter comes up, the judge says, yes, Mr. Chaudhary, are you ready? But the problem, what problem? Oh, material instruction, you have not
Yes.
received.
Always, there is always problem with the advocates.
Item 33 and 34.
I'm deeply obliged, my lord.
Okay, okay. Only two cases.
They are not here.
Yes, ma'am.
Yes, Lordship, in this matter, we have received the affidavit reply filed by the petitioner's lordship. And we need to go through this lordship.
You need some time.
Yes, Lordship.
You just say straightforward, you need some time, that's all.
Lordship. And after the Puja vacations, Lordship.
Puja vacation.
Can it be on 24/10? Can it be on 24/10?
Lordship.
24/10.
Because advocate and I will be appearing, I'll just check Lordship and.
You just confirm, ma'am.
Yes, Lordship.
Give a consent date, please.
Lord.
Item 37.
Highly obliged. The Lordship, kindly this matter may be taken after Puja vacation.
Thank you.
Bless you.